morning, everybody. Happy Wednesday, which I believe officially is the new Friday. Welcome to the Courtroom Files Live. I think this is the third day in a row doing this, but let's start with Judge Dad.
5 days in jail. Do you understand that? I can't hear.
Yes.
Did you sign this advice of rights form and read and understand the rights? If you plead guilty at any time, you will be giving up all those rights and there will not be a hearing. Do you understand that?
Yes.
You do have the right to an attorney. I'll be happy to provide you with one at public expense. Do you understand that?
Yes.
Would you like a lawyer?
No.
The charge, you failed to clear all your warrants within 30 days of the date of your jail release. How do you plead? Not guilty? Okay, I'll get probation in here, then we'll have a hearing. You cleared all your warrants?
Yeah, well, clear everything.
When did you clear the last one?
The last one they just scheduled it.
Call in Beth.
It was for Dearborn, and I just had to get fingerprinted.
What about the one out of Detroit from July of 21? Did you clear that warrant?
Sure, I already got
Okay, so you want to have a hearing though?
it.
But you still want to have a hearing, right? Okay, so, all right. Okay, we'll get Ms. Wiles in here. She'll testify and we'll go from there, okay? Hernandez, Jose Charles Hernandez, file number 25W83953A and B. And also, 5W839, I have 523A and B and 532A and B. Your name?
Jose
Jose what?
Hernandez.
You're charged with driving on a suspended, defective equipment. You're also charged with driving on a suspended and defective equipment on another case out of Brownstown that happened about 40 minutes, 30 minutes apart. You have the right to a lawyer. If you want me to give you one, I will. Would you like a lawyer?
Yeah.
Okay. You can go out in the hallway. He'll set you up with an attorney. And then either way, after you speak with the lawyer and the lawyer speaks with the prosecutor, you'll come back in front of me with your lawyer. Okay.
I cleared my suspended.
You can go out there and talk to the lawyer. The lawyer will assist you. Okay.
This way?
No, that's lockup.
Same way.
Recalling Lamar Eugene Thornton, 24B 702123 FY. All right. Your name, sir, again? Ms. Wiles?
Elizabeth Prosecutioner.
All right, so defendant pled not guilty to the charge that he failed to clear all of his warrants within 30 days of his release from custody. I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. Okay.
Yes, Your Honor. As far as going back, the defendant had several warrants out at the time of his sentencing. He was ordered to clear those warrants on August 18th, 2025. I did run Mr. Thornton's record at that time on August 18th, which is going to be the date of the show cause. Mr. Thornton did still have a bench warrant dated 11/4/22 out of 19th District Court. Looks like this was a false ID charge. He had another warrant dated January 3rd, 2024 out of 25th District Court. That was for a civil infraction.
Did he add one on July 6th of 21 out of the 36th? That's the only one I'm seeing on this clean printout, but it's dated September the 9th.
Yeah, and I did speak with Mr. Thornton. He was making attempts to clear those up. I am seeing one out of our court issued August 8, November 1 of 24 out of 23rd, November 1, 24 out of 23rd, again, November 1, 24 out of 23rd, and then, as I mentioned, January 3, 24 out of 25th, and November 4 out of 22.
Do you have this one, July 6th of 21? Driveway license not valid?
I am not seeing that one on my printout, Your Honor. I'm not even seeing that as issued even during his.
Well, let me hand you this lien printout here. Sir, do you have any questions of her?
For the most part, I got order.
Do you have any questions of her? Do you want to testify or do you wish to remain silent?
Like to speak.
Okay, so if you're going to speak, this is a hearing, I'm going to swear you into an oath. Is that what you want? Sir? So this is a hearing right now. I'm determining whether or not you had warrants outstanding 30 days following your release from custody. She just testified. You said you don't have any questions. If you wish to testify, I have to swear you to an oath. Do you want to testify or do you want to remain silent? If you remain silent, I won't hold that against you. Do you want me to swear you to an oath? Sir. You can't just, you see that I administered an oath to her, right? You see me ask her to raise her. If you're going to speak now, I've got to ask you to raise your right hand and I'm going to swear you to an oath. Is that what you want?
Wanted to, it's like when you swear me, do I have to go against her or like, can I just say,
You can tell me,
like, that's when I'm confused. I don't know if like I gotta go against her or not.
what do you mean go against her? She thinks you didn't clear all your warrants. You pled not guilty. She just testified you had a slew of outstanding warrants 30 days after your, listen. I don't know what you mean by go against her. I've either got to swear you to an oath, in which case you're giving up your right to remain silent, or you can just tell me, Judge, I do not wish to testify. And I'll give you an explanation if you find me guilty following your decision on whether or not I had outstanding warrants 30 days after release. Do you understand? Do you want to testify? Okay. All right. So based on that testimony, I find that you violated probation.
Your Honor, I just want to say the warrant that you're providing, Mr. Thornton does have aliases. It does appear that this one warrant that you have from July 6th of 21 is under one of his aliases.
Right. All right. I'm going to find you guilty of failure to clear all warrants within 30 days of release from custody. Now, listen, how many do you think you took care of? I need to know how many. Did you take care of one or 42? How many warrants did you take care of?
5.
Okay. All right. Good enough. I'm going to keep you on probation. Pay additional costs of $50. Clear all warrants by October 1st now. Do you understand that? Okay. So you just clear all your warrants, you pay $50 and we're done. At least with regard to this violation. You understand everything?
Yeah.
Okay, so can you pay the 50 now or do you need time? So you pay that 50 now. Remember, you got to clear all your warrants, including this one out of Detroit. Ms. Wiles, will you tell them about it, please? Show it to them on the lien. We can't give you a copy of the lien printout, but you can at least show it to him. And he can go over to Detroit and take that.
Absolutely, Judge.
Okay, take care of that. Good luck. Thanks. Corbett, Clarence Lee Corbett, the third, 25 WA39 349 A and B. We have a warning on a no proof. We have a drivewall suspended and expired plate. Your name, sir? Corbett. You waived your lawyer previously. You met with the prosecutor. You were going to plead responsible to expired plate. You've got a valid license now, which is a good thing, with the understanding the drivewall suspend will be dismissed. Is that true?
Yes.
To the charge expired plate, how do you plead responsible or not responsible?
Responsible.
Plea is accepted, suspends dismissed, fines cost $135. You go down the hall and take care of those. Do you have valid insurance?
Yes, sir.
Okay, good. Good. Take care of yourself. You can pay the 135 now, right?
Yes.
Good luck. Right down to the cashier. Anything else down there?
Good morning once again, everybody. Happy Wednesday, which is the new Friday. Welcome to the Courtroom Files Live. Lady Jax just joined us. Good morning to you. Good morning to everybody. Let's do this. Let's go to Texas. We'll say good morning to Judge Stevens.
Okay.
And
No.
25 CR 817 is called the state of Texas versus Michael Jenkins. That's you, sir. Sir, you have been indicted. You probably know this with burglary of a vehicle, which is a state jail felony. You have 2 prior convictions of burglaries of a vehicle. Something about burglaries of a vehicle that attract you. But further, you've got several. This is 3 pages long, and we're talking about several prior convictions dating back to 2008 out of Gregg County, illegal possession of a controlled substance, a second-degree felony. After that was finalized, then you committed burglary of a habitation, a second-degree felony, and were convicted here in Jefferson County in 2013. And also in 2013, you had a second burglary of a habitation conviction. And looks like after all of those prior convictions were final, you were convicted in 2017 for delivery or manufacture of a controlled substance, a second-degree felony out of Montgomery County, Texas. So it looks like what we have here is a second-degree felony in paragraphs 1 and 2. I'm sorry, a state jail felony with paragraphs 1 and 2. And then the prior convictions will enhance it to a second-degree felony punishment.
That's correct.
That's correct, Judge.
Okay, so you're looking at up to 20 years in prison, sir. And you're not eligible for probation in front of a jury because of your rich criminal history. You understand? So, okay, Mr. Dusler is going to represent you. You were indigent. You have to speak.
Yes.
There we go. She has to take everything down here. Look, the court reporter. So go ahead.
I just met him this morning for the first time.
That's
This is an initial. Well, we
Brendan?
visited and his mother's here. And I've explained to them the gravity of the situation.
Oh, yeah.
He does appear to have had some mental issues in the past, but he doesn't appear to me to be incompetent at this time. So I don't feel like filing.
I think that would have been,
evaluation.
unless it's just a recent onset. There are so many courts have dealt with this already,
Right.
and they would have been sensitive about dealing with capacity,
Yes, sir.
mental capacity issues.
So
But I don't see anything that reflects he's been diagnosed as incompetent or
yeah,
insane.
I didn't see that from the visit I had this morning, but we've discussed with he and his mother that it might behoove them to try to hire an attorney. So I think they're going to explore that. This is a brand new case.
Well, you're a competent lawyer, but if they can hire it, then the taxpayers aren't going to pay for it.
So we're just asking for a normal reset to see if they could do that since this is initial.
Okay, I'm going to give you 5 weeks
That should work.
to talk to some people. If that's what you want to do, but this man's a good man. He's a competent lawyer, but you can hire anybody you wish. And if you are unable to financially, then the taxpayers will pay for it. But I always prefer people to hire their own if they can. But these are competent lawyers we have. So I'm going to reset it 5 weeks to get a lawyer or come back and see where we are on what direction this is going to head. Has an offer been made on this at all?
Yes, I have relayed an offer.
Well, just, I'm curious about it because of a criminal history like this.
10 years TC.
Was there damage to the vehicles? Is there any restitution?
It was actually not her offer. It was Mr. Eckert's offer way back.
Well, it's an offer by the VA's office.
It is.
I don't believe we've been able to confirm the amount of restitution at this point.
All right, then please get a resetting. Thank you. And so Dylan LaFleur, Jose Rocle, those two have been reset. Durwood Stanley.
Judge, Mr. Stanley, we're trying to confirm that there's a death certificate. I believe this defendant has passed away.
There is a Durwood Hugh Stanley obituary.
That's correct,
August-
Judge. We just haven't gotten the
7/4,
actual
And that
certificate.
would be
She's going to give you the reset.
Yeah.
August 4th.
He's on.
So this is May 2nd, and that conforms with the date of birth in the indictment.
Mhm.
And he's charged with state jail felony and criminal mischief a year ago. And okay, so well, let's reset it a couple of weeks, but if y'all find out that it's
I'm hoping that I'll be able to find out today.
futile because of his, he's actually deceased, we can dismiss it. Yeah, thank you. Okay, Cullen Cannon. I have two cases, right, Brent?
Yes, sir.
Mr. Turk on Cullen, Cullen Cannon?
Yeah.
You're Cullen Canton? Cullen Canton. Cullen Cannon?
Yes, sir.
All right, Mr. Cannon, this is an announcement. So we've already gone through an initial appearance, I guess. As you know, you were indicted on April 2nd in two cases. And they are numbered 25 CR 398 and 399, which similarly allege aggravated assault with a deadly weapon. And it looks like what happened. There was I guess your vehicle collided with another and two people were in the other vehicle and they were injured. Thus, the grand jury deemed that you were at fault by intentionally, knowingly, or recklessly striking the other vehicle. So you're looking at, if it were only that, in each case, no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. However, there's a prior conviction alleged out of Belmont County, Ohio in 2022 that states that you were convicted of failing to comply with an order or signal of a police officer, which is a 3rd-degree felony there, and aggravated possession of drugs. So if that were true, proven true beyond a reasonable doubt, you were convicted of one or both of these 2nd-degree felonies, your punishment is enhanced to a 1st-degree felony, which means you're looking at no less than 5 nor more than 99 years confinement in prison or life in prison. And up to a $10,000 fine can be also assessed. Mr. Turk's a good man. He'll guide you through this obstacle course, but you have to recognize this is very serious. Anything with life imprisonment as a potential punishment ought to get your attention.
Yes, sir.
So, today is an announcement. But you had time to make a determination.
Judge, we just got the offer, and I just got the discovery, and I haven't had a chance really to go over it with Mr.
We give
Kennedy.
you 2 weeks.
Would you be able to get in my office within the next 2 weeks?
It's your life. You got to make it.
Yes, sir.
Figure it out. I'm going to give y'all 2 weeks. I'm saying that because the indictment now is 5 months old. You're still living at Port Bolivar?
Yes, sir.
Okay. And you have to understand if this allegation in the second paragraph is true, you are not eligible for probation in front of a jury. If you went to a jury trial, if you were found guilty, you'd be looking at no less than 5, no more than 99 years. I don't know if there's something here that is workable for probation, but you can only get it in front of the court through an agreement.
Yes, sir.
But we'll see you back in 2 weeks, okay? Please
Thank you,
get a
sir.
resending.
Thank you.
And Camilla LeBeau is called in 25 CR 849. And you're Miss LeBeau,
Yes, sir.
and Mr. Turk is your attorney, correct?
Yes, sir.
And in this case, ma'am, you probably know you are charged by an indictment here with the state jail felony of injury to a child 14 years of age or younger. And it says you struck the child with an extension cord. I guess that was some kind of discipline theory. And so you were looking at, if convicted, no less than 180 days, 6 months in a state jail, up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yeah.
I don't see any criminal history on this lady at all. Right?
I don't think so, but I have not.
You still are on San Anselmo?
Yes, sir.
Okay. So
She does have some criminal history, Judge.
a conviction of a felony?
Looks like she
This is-
had a probation
Regular?
back in 2018.
Not injury to a child. is it?
She's advising that it's deferred.
How many children do you have?
I have one.
Okay. Well, discipline is, I grew up with it. And in the old days, there were unique forms of discipline that have been ruled unlawful as we were growing up. Things have changed,
Yes.
and you got to be sensitive about it. Discipline is important because children sometimes have to be disciplined. But the parent is two things. You were a role model for the child. They're going to emulate you. Plus, you're in control of the child. They really can't do anything much to fight back. So you're in a dominant position, which you have to use your authority and power wisely and with discretion and reasonably.
Yes, sir.
So these are the kinds of things that are workable. Did the child have to go to the hospital or anything like that? Or I see the child reported it, it looks like, to authority, to somebody at school. But you didn't have to go, the child didn't need medical attention. Well, that's good. This ought to be fixable with a method of maybe, I don't know, here's the deal is parents sometimes the parents need to learn a lesson, you know, of how to deal with things in a responsible way, because children are protected under law. They should be. They're vulnerable.
You do have the PC, right, Judge?
Yeah, I just read the first paragraph. Okay. This, according to the probable cause affidavit signed by law enforcement, was stating that the child exhibited injuries 12 days after the event. That's not good. But you got to figure out what the issue is and make sure that this can't happen again. Better ways of disciplining a child, because under the law, children have great protection, and you harm a child, you have to pay serious consequences for it. Okay. We're going to put it on an announcement docket, 4 weeks. Thank you. I have Logan Bertram and LaJuan Kirk. Looks like those are reset. Michael Stelly is next. John.
Yes.
That the only shirt you have,
Yes, it won't be clean.
sir? The only one? Yeah.
Clean.
Yeah, it's what goes on in here is the Constitution, and it's not a football game.
Yeah, I didn't
You
wear
have
it.
your colors that you want to sport, you know, you've got to kind of just look at everybody. You're the only one without a tie.
I know I was gonna wear my night shirt, but I didn't have to.
Okay.
Wore my night shirt, so
Are you employed somewhere?
yes, sir.
Where?
With Chuck Mitchell Construction.
What do you do? Build?
Yes, sir.
How much what do they pay you by hour?
$15 an hour.
Yeah, well, that's, you know, that's 35 to 40.
Yeah, we got to work, you know, they don't always have work. Construction, you know,
Construction of homes or other buildings?
Yeah, we build new homes and then we do repairs.
Yes, sir. Okay. Have you ever been in legal trouble before?
Yes, sir.
Well, you know, there's kind of a honor in this room because of what we're dealing with. So dress nicely, okay?
Yeah.
All right, here's the problem. Because of your prior convictions out of Hardin County and Jasper County for thefts, if you steal a pack of gum, it's a felony.
Yes, sir.
From here on.
Yes, sir.
So anything and here was tools of a value of less than $2,500, but still, you steal a pack of gum, they catch you, you're going to be looking at up to 2 years in the state jail.
Yes, sir.
That's just the way it is.
Yes, sir.
Live honestly. Harm no one. Give each person respect. That's the
Yes, sir.
fundamental rules.
Yeah, I'm learning a lot, you know, lessons in life.
Well, how's that working for you?
It's doing pretty good. I mean, I'm not really, not as rowdy as I used to be. I guess you could say I got kids
Yes,
now,
sir.
so I do pretty good. Not, you know.
Well, you're
Keep it
30,
up.
what, 36?
Yes, sir.
Yeah.
I still feel young at heart, you know.
Well, you can be young at heart when you're 85, and that I think that's great. But just don't be
Still,
young in choice making.
yes, sir.
You don't make childish decisions.
Yes, sir.
Also, you have children,
Yes, sir.
and you heard me. You're a role model.
Yes, sir.
They're going to emulate you. They're going to, and if they make mistakes, if they say, "I'm doing this because this is what I learned from Dad," Whose fault is it?
Just having children and telling me like you're messing up, Dad. Like,
Well,
you know.
I have children and now grandchildren, and I can't imagine how I'd feel if I felt like they were emulating me in a bad way.
Right.
So, but that's a natural tendency for children, and it's not their fault.
Yes, sir.
You've got a responsibility
Plus,
to act responsible.
plus I don't. My daughter don't have her mom, so she's.
My God, well then what are you
Yes,
doing?
she only has me,
What are you
yeah.
doing in here? Did you
Yeah.
have any business? You got
Yes, sir.
important. I mean, that's,
That's one of the things kind of jumped on me, you know.
where are you in life? Number one?
Yeah.
No,
supposed to be.
no, you're not.
Not supposed to be. So.
No. Others are ahead of you. Your children, your family. You're third.
I got some garden on the table.
Good for you. That's right. Creator
Yes, sir.
brought you in here, then others,
Right.
then you, especially your children. But here it's theft, and it's not necessary. You got a job.
Yes,
You got children. Fix this. I'm sorry, John. I was making a word on there.
That's just kind of.
Well, I thought a speech that needed to be said.
Your name's on the front out there, not mine, so you can speak all you want.
They hadn't torn that down yet?
Yeah.
Big
What
bold
do we want-
letters.
What do we want to do
Your Honor,
today?
he has a pending case in Hardin County still right now that I would like to resolve first because it's a little more serious.
What is it?
That is, what's Hardin County?
They said burglary habitation, then the burglary building. So I'm innocent. I'm taking a trial because it wasn't me, honestly.
But have you been indicted for burglary of a habitation?
Yes, no, indicted. It's pending.
For habitation?
I'm not sure if it's, no.
Because there's a big difference.
Yeah.
One's a state jail felony, the other's second degree
Yeah,
felony.
I was arrested for habitation, and then when I got to over there, they told me burglary building. So I don't understand. I don't even know what I wasn't even around.
Well, technically, a habitation is a building, but the charging, a commercial building or a building that is not a habitation that's burglarized is treated as a state jail felony. If it's a habitation, it's more serious. Somebody's home.
Yes, sir.
A habitation is going to carry with it up to 20 years in prison. So,
Yes, sir. Oh.
But I
anyway,
have,
these are things, no, you gotta fix. You gotta
Yes,
fix
Yeah.
this.
And I'm his attorney in Hardin County as well, Your Honor. I was appointed in representative here to be on that as well.
All right.
So, as soon as we have.
How much time?
Let's do 4 weeks.
You got 4 weeks.
I got
Get it
Get a
started.
resetting there. Yes, sir. And
You know, I just have to say real quick that listening to the speech that he was delivering to that guy about priorities and stuff like that, you know, it makes me believe even more that that case that we saw with him that we all hate, somebody had to have gotten to him, because that's the kind of viewpoints that he regularly espouses. And then there was that outlier. So I don't totally get it. But let's go back to him. We'll watch another defendant or two, and then we'll move on to another court.
setting. Devontae Jobert?
Did you come to your command approach?
Yeah. Is that a beer?
I wish.
I heard a,
Sorry, I'm moving a little slow.
I heard that. I recognize that noise.
Right there.
And we now call 23 CR 168 for State of Texas versus Devontae Jobert. You're Mr. Jobert? Okay. And today we have Mr. Paggard is going to represent you, correct? Okay. You're retained on this one?
I am, Your Honor.
We had you on probation. Good Lord. Earlier this year, we put you on regular probation, right? 10 years in prison, probated for 10 years, and $1,000 fine for the third degree felony of evading arrest or detention with a motor vehicle. And that was on January 28th this year. Now, there's a motion to revoke probation that alleges, and this was filed, by the way, on September 15th. Oh, it's fresh. Just a couple of days ago. that you, number one, committed the offense of operating a motor vehicle while intoxicated with a child under 15 years of age on or about August 30th, 2025 in Jefferson County, Texas, and that's serious. Two, you were at a location other than your residence at 1:08 a.m. So you busted the curfew, I guess, on your probation order on that one. Failing to abstain from the use of any and all intoxicating substances, including alcohol. And this is in conjunction with allegation of the DWI alleged earlier. And finally, it is alleged you failed to pay court assessed fees as directed, and you are behind or in arrears in those fees, which is also a violation of probation. So there's 4 reasons that have been placed in this motion that's alleged. The motion is viable, and it's alleging and pleading that a hearing be made, and we will do that to determine whether your probation should be revoked or not. Let me look at something. What's the results of the blood?
It's not back yet, Judge.
It's not. Yeah, this not a good set of circumstances here.
It is not, Your Honor.
This. Looking at the public safety report, like DPS provides, that we all look at now, in determining the appropriate rules for setting bond in cases. This public safety report goes back to about 10 years now of criminality, beginning with there was an assault, a misdemeanor assault, but it does not have a finality to it. Then in 2016, theft, 1 year probation, aggravated assault, felony, and it says disposition modification, probation 1 year. So it must have been reduced somehow. It doesn't say what location. Then we have an unauthorized use of a motor vehicle, state jail felony, which was adjudicated.
What year is that, Judge?
16.
Right, so that's when he was a juvenile. Your PSI reflects that
Was he treated as a
robbery was changed to a theft from person at the same time with the unauthorized use, and he was given TYC commitment. both felonies that could be used to enhance his punishment.
2019, we have a robbery, a second degree, 10 years probation. Are you still on probation for that?
I'm sorry, I'm gonna get 4 years.
Your probation was revoked?
Yes, sir.
Mhm. I've got a misdemeanor class B theft in 19, another that resulted in probation revocation.
That one reflects, Judge, that was out of Orange County where he was given 15 months probation. It was revoked, and along with
180 days is what he gets.
with 11 other misdemeanors, he was given 180 days on that.
Okay. And those misdemeanors are series of thefts.
They're all thefts except for one evading
arrest. I'm sorry, a criminal trespass as well. Then we've got in 2022, a third degree felony of evading arrest, 10 years of probation, which I guess is going to be this offense.
That's this offense, Judge, but that arose out of 2 events where he was found guilty of indecent exposure. He got 60 days jail time. So those were events that he was doing out at Lamar that resulted in he was actually running from the police officers whenever this was, the warrant was outstanding for those indecent exposures.
Okay. And then we have this case.
Yes, sir.
All right, Mr. Faggard, as the defendant's attorney,
Yes, sir.
give it your best shot.
Okay, Your Honor, while his record is bad, I wanted to bring, he's going to request a bond. He's currently employed. He has 2 different jobs. One is working for Williams Brothers Construction. He also works for Beva Auto Sales LLC on the side. He has, he's agreeable to, I would understand the court's concern about letting somebody out with a DWI without some type of scram device or other ways to monitor his movement and conduct. He's certainly willing to do that. He understands that he needs to get help for the drinking. He's agreeable to go, if the court agrees to it, to go to the JCDI program or any other program that he needs to get help so he can get out of this cycle that he's been in. He has the ability to make a bond. He has a bonding company that is on standby. And most importantly, Your Honor, there are 2, he has ties to the community here. He also has the support and mentorship of Pastor John Adolph over at the Antioch Missionary Baptist Church. Antioch. He has been mentoring this young man. He sees a lot of good in him. Everybody's trying to work with him to get him out of this life of crime. Also, Your Honor, before the warrant for his arrest was issued, he'd been meeting with Rod Carroll on a daily basis about the need to change his life, to move forward. He certainly, I believe that with some good mentorship and some good directions and some supervision by the court on, you must do this and you must do that to maintain sobriety and never drink again or never violate your probation again. I think there's really hope for this young man. So I'm going to ask the court to take all that into consideration and set a bond for him that he'll be able to make with it whatever appropriate conditions the court may wish to impose as far as monitoring, no drug use, attendance at outpatient programs, things of that nature. Because we'd like to keep him on bond until we see if we can get all the other case resolved, the new case as well.
I was promised all that before I reached the agreement back in January. The whole Pastor Adolph card, and all that
It's
stuff.
familiar.
They came with me about that. I wanted him to go to the prison for what he did originally on this. And so I'm standing here with egg on my face because I gave him an opportunity, and I'm not going to agree to releasing him at this stage, Judge.
Yeah, nobody should ever be embarrassed for trying to help a situation and give somebody a fair chance, which is what I did when I placed you on probation. And I stuck my neck out with your rich criminal histories. You have, here's a couple of things. There is no bond right now. I want to wait. This first question I'm going to ask you. You told the police when they stopped you here in this probable cause affidavit, and you admitted to drinking, and you told them you drank 2 beers, correct?
Yes, sir, I did.
You're standing by that?
No, sir. I went up.
You lied?
Yeah, I went up there and I admit I spoke with Chief Roy Perry and I told him the truth.
You didn't, yeah, the probable cause isn't done by Chief Carroll, though. It's by somebody else who did this probable cause affidavit. But why would you lie to the police at the scene?
Because I don't want to go to jail. And it's just being honest, but I'm still feeling.
You think lying is going to get you out of trouble?
Oh, sir, I know.
How much did you drink?
I'm gonna be honest with you.
No, really, you promise?
Yeah, yes, Your Honor.
You should have been honest the whole time.
Can we swear him in?
Raise your right hand. Do you solemnly swear or affirm any statements that you may make will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hands, sir. And you don't have to say anything.
Yeah.
If you don't want. If you don't want to.
If you want to, this can be used against you later. No, it's a preliminary hearing.
It can always, anything
Okay.
that's freely and voluntarily made
Yeah.
is always admissible to against
I
anybody.
ain't fighting, bro. I'm wrong, I'm wrong. I'm just trying to get a close.
Look, I'm gonna wait until the blood tests come back before I make any decisions on what direction this is going to go. Do you have any idea when we expect a result?
I haven't seen the paperwork yet, Judge, and I checked again this morning.
2 weeks? What does it normally take? I don't know.
I can make some calls and try to find out, Judge, but I don't want to hazard a guess at this stage.
Here's what I'm going to do. Is tentatively set it for review in 2 weeks.
I can find out in that time frame at least.
Give everybody enough time to get your positions of strength ready on where we're going to head here. But at the end of the day, the court has reviewed the public safety report, which is terrible. You are on regular probation in this court, which means you've been convicted already. And your choices and conduct are the determinations of where you go next on this probation. And you don't get a jury trial. It's in front of me. Now you have a right to a jury trial on any other new charges that may come about. But my guess is that this DWI is going to come out.
Yes, sir. It's a state jail felony offense.
And it'll end up here. So we got to wait for that also before the thing can be disposed of. But it seems, have you ever had any assistance medically for any problems that you've had in this rich criminal history of yours?
No, sir.
Well, what is just rhetorically, why are you here? You know, I'm not talking about the facts of it, but why do you, you've got children, you've got responsibilities. Why are you putting yourself first and not last?
It's like a demon I can catch off.
Say that again.
Yes, I gave you my copy, Judge. Thank you.
Go ahead,
It's like a demon I can't fight off, Judge. I be trying my hardest.
sir.
I say it's like a demon I can't fight off. I'll be trying my hardest. Man, I haven't been out of jail since I was 16 years old. I've been going to jail my whole life since I was 16.
But you were, but
Then I get out.
but you know, choices have consequences. You
Right, I
make the
know.
right choice, you get rewarded. You make the poor choice, you get punished. All of us are, that's the standard we all have to face. But why is it consistently the bad choice you choose? But you know, it's like you keep putting your hand on the stove, and now you are just not putting your hand. You are embracing the hot stove because you know it's going to burn you. Now, it's a rhetorical question to think about.
I think about it all the time.
How'd you do in school? Did you have poor grades or good grades?
I had dyslexia in school.
Well, that doesn't mean that you're unintelligent.
Okay.
Okay, there you go. That's something to start off with. You're capable of thinking correctly and making the right choices and analyzing issues and being intelligent in your thinking. Would you agree?
Yes, sir.
And you have the greatest, how many children do you have?
I have two men. I've been trying to.
Wait.
I've been trying.
Once again, those are gifts. Those are precious that their outcome, what direction they head in their life is directly related to parental examples.
It's like I'm stuck in bind. I'm not gonna be able to pay this man. I'm gonna lose my job, then I'm gonna be out with a 410 lawyer fighting my life with him.
Well, isn't that what happens when you make bad choices? That's why, you know what? You're a smart guy. Why don't you think, I'm about to make a choice here. Is this bad choice going to result in problems that I'm going to have to deal with? Well, look, I'm looking at this. You know, intoxication and driving a 4,000-pound missile is trouble and it's illegal. And you've got a child that was bouncing around in the car without any stability, wasn't in a protection device. They found the child just free and loose in the vehicle, and then you're the first thing out of your mouth when the police talk to you was, "I have 2 beers," and we know that can't be right.
Yeah.
Because when the test comes out, it's going to show how wrong you are. But the police may have saved your life and your child's.
That wasn't.
Because you're on the highway doing 40 miles an hour. And all they got to do is a big rig drive over you and we're all at your graveside. But everybody makes choices and you have to pay the consequences. But here's the deal. You can always start from that last mistake and do better.
That man was sent me to prison. Man. I already know he tired of dealing with me. And man, I can sit in and I can talk as much as I want to talk. And that man is tired.
Yeah.
That man been saying me since I started.
Well,
you know,
hey, once again,
Choices.
it's choices and the consequences. Just like, look, can you imagine what would happen to me if I fouled up? Well, I got to pay a price. That's why I try to make the right choices. And he's a good man. He's going to help you. He's a very decent man. I know him. Take his advice. You're lost in the woods. He's going to try to pull you out of the woods. But let me just say, anticipate this. This is going to sting some. However this ends, it's going to end up stinging. But then it's how you deal with it, which is the test. Or you can just go over there, sit down, cry, and give up. And give up and walk away from your family and all those blessings that the Creator has given for you. Why don't you start from here and do the best you can be? Because I believe you're capable. Then let's move forward from here. You got to deal with this, but it's what happens here on after that's going to be the test of your character, sir. How we deal with our problems, that's the real test. Are you going to fail or are you going to be a rebel? a role model for your children, and it's not too late to start. We'll see you in a couple of weeks where we are, okay?
Thank you. Yeah, I was one of the reasons I wanted to get him out on bond was probably when I got paid, I was going to hire a mitigation person to look into his psychological background.
Yes, sir.
And my hands are going to be tied with that. I will deal with him on that.
Well, all that's psychological and all, but that didn't have any, I don't think that had a lot to do with the DWI. That's choice making on alcohol, and that
I understand.
you can't say I've got a mental illness that keeps me. Well, I guess you can develop alcoholism, but you don't throw a child in the car and put them in harm's way.
Well,
okay, it's reset. We got a trial, and we'll see you everybody in 2 weeks.
Barbara, thank you for gifting a membership. Very much appreciated. I was just saying what a great group of people this is to Donald, and this is why, one of the reasons why Donald, an incredibly generous and supportive group. Let's go to Judge Glazer, Miami-Dade, for the first time in several days. They've been doing upgrades to their equipment there. So she was out of her regular courtroom for a while. She was back in it to start the week, but they were still having audio issues, but they fixed it now. So let's see how hangry she's getting.
And then there's the cocaine case. He had a crack pipe with cocaine residue and one suspected crack rock in his left cell. There's probable cause for the charges here. F25-20247 is 25. It's only one count each. Count 1 is $2,500. Count 2 is an ROR. Count 3 is $500. Count 4 is an ROR. Stay away from the Navarro. Visit the division judge. They may decide they can give you TAP, but I'm not doing that today, sir. Good day. Thank you for coming in, officer. Next case.
Donald, thank you for the super chat. Very much appreciated. You are also a very generous and supportive member of this group. I'm telling you, this is the best place in LawTube. The fact that we don't have 500 viewers a day on this show amazes me, but we will get there because we continue to grow, and that's with the help of all you guys. So thank you so much.
Good morning, Mr. Herrera. Do you speak English?
Yes, I do.
Thank you. There's somebody here. Mr. Crockett is here. I've just promoted him. He says, I believe he's your attorney.
Yes, ma'am.
Okay. Give us a moment, please. So you're in charge of battery by strangulation and also conspiracy for tampering with a victim.
Good morning, Your Honor.
Crockett, how are you? I'm sorry about that. I'm sorry about that.
Don't worry, Your Honor. Your Honor, I'm here for this bond hearing only. He's going to need the public defender, but I do want to argue on his behalf on bond when we get there.
So let me explain something. You have to turn off your Zoom because I'm getting feedback.
Okay.
You got two devices going.
Do I? I only have the.
You only have one device on?
Yes. Yes.
Okay, give me a second.
Okay,
give me a second because I'm getting an echo of everything. Louis, can you come in and help me, please?
Judge, is it just when Mr. Crockett is speaking?
What?
It's just when Mr. Crockett is speaking, correct?
Can you hear me?
I can hear you.
Okay, good.
Okay,
it stopped. Okay, so let me just explain. I can't provisionally appoint you. You can you're either representing him or you can't. If you're going to be representing him, that's fine. But if you want to withdraw, you got to do a motion to withdraw before the division judge. Or I can appoint the public defender now if you can't afford an attorney, whatever you want.
He cannot afford an attorney, Your Honor. I'm asking if I could make a limited appearance simply for today.
We don't do limited appearances here. That's the problem. So if you want to represent him, you'll have to do a motion to withdraw, or I can appoint the public defender's office if you can't afford a lawyer, and you're more than welcome to speak on his behalf if that's what you wanted to do.
Okay, that's what I want to do, Your Honor.
Appoint the public defender?
Yes, Your Honor.
Okay, before we get there, Mr. Herrera, can you afford to hire a private lawyer? I will appoint the public defender's office for you. So let me review. It's an incident from the 15th at the Miccosukee Casino and Resort. Okay, I had a chance to review the arrest affidavit. Ms. Corey, anything you want to say?
Yes, Judge, I'd ask you to find no probable cause for count one, battery domestic by strangulation. There's nothing indicating the airway was obstructed in any form. At best, it would be a battery. And with regard to count two, I'd ask you to find no probable cause. There does not appear to be any conspiracy to tamper with the victim or witness.
So
she's correct.
Right. So it looks like the victim suffered some pretty significant injuries and also temporary lost consciousness. So she was beaten pretty badly and fire rescue needed to respond. In terms of the tampering, I think the officers are trying to charge that because he had a friend come and pick him up from the scene, but I'm not sure if that charge is appropriate.
Thank you. Sir, do you currently live with the alleged victim, Ms. Delfino?
Yeah.
Or do you have to go back to the home to get into her home to collect any of your personal belongings?
No.
Pardon me?
No.
Thank you. And Mr. Crockett, did you want to say anything on his behalf?
Yes, Your Honor, just that this is a matter that will be disputed. There was no battery according to the defendant. The defendant is a veteran, but with very few funds. His mom will help him. So I was going to ask for a bond in the area of $1,000 and $500 on the two charges, assuming there is probable cause.
All right. Thank you. And so, sir, did you ever live with the victim?
Yes, I did.
All right. So I'm entering a stay away order from the alleged victim, Georgina Delfino. No contact with the alleged victim, Georgina Delfino, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you have to go to her home now to collect any personal belongings?
No.
Thank you, sir. Do you understand the stay away order?
Yes, ma'am.
Thank you. So as to count one, there's probable cause for battery. That bond will be $1,000. Count two, there's no probable cause for conspiracy for tampering with a victim or witness, release outright. Just stay away from the victim. All right, thank you so much for coming in, Mr. Crockett.
Thank you, Your Honor.
Thank you. There's any more officers here? I thought I saw another officer. I don't know what case you're here for. You gotta raise your hand so I can promote you. Okay, next is Paradad Garcia. Page one.
Need the Spanish interpreter, please. Good morning.
Good morning, ma'am. You were arrested for petty theft, 2 or more convictions. I will appoint the public defender's office for you.
Buenos días, señora. Usted fue arrestada por hurto de menor cuantía, 2 o más condenas. Voy a asignarle a los abogados de oficio para que la representen.
So there is probable cause for the charges.
Sí existe motivo fundado por los cargos.
Ma'am, you were ordered to stay away from the WSS store at 99 Southwest 12th Avenue in Miami, Florida.
Señora, a usted se le da la orden de mantenerse alejada de las tiendas WSS que quedan en la 99 Southwest 12 Avenida en Miami.
All right, so I'm setting a bond. She has an open petty theft case set for trial.
Would you consider the TAP program, Judge? Ms. Garcia is currently homeless and has no funds for a bond.
Tiene un caso abierto que está para juicio, entonces le voy a fijar fianza. La abogada ha pedido si se puede tomar en consideración el programa TAP. Ella no tiene fondos para pagar una fianza.
She has pages
Y no
of
tiene caso.
priors. I'm not giving her tab. She has pages of priors in an open petty theft case set for trial in October. $2,500 bond. Good day.
No, le voy a fijar una fianza de $2,500. Ella tiene varios casos y tiene un caso abierto para juicio en octubre, entonces no se le da el programa TAP. La fianza es de $2,500. Que tenga buen día.
Next case, Olga Castro, page 1. Good. Line them up, corrections. Don't you want to finish soon?
Ms. Castro is present. She speaks English.
Good morning, ma'am. You were arrested for possession of a controlled substance called heroin, possession of cocaine, and possession of drug paraphernalia. I will appoint the public defender's office for you. Ma'am, do you have an address where you live?
Yes.
Pretrial services, alternate bonds. Count 1 is $2,500. Count 2 is count 2 will be $1,000, and count 3, $500. Have a nice day. The pretrial.
She's holding pretty strong as we approach lunchtime there on the East Coast. Let's go to Michigan. We'll say good morning to Judge Simpson. Who's got some audio issues? Let's bump him forward a little bit, see if they fix that.
Yes, sir. Yes, sir. All right. You are before the court on a misdemeanor complaint that alleges that on or about January 29, 2025, the location of the Meyer store at 635, which one is this?
Carpenter Drive.
Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of retail fraud in the second degree. Do you understand the nature of those charges?
I do, yeah.
All right. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
I do, yes.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, I do.
All right. Public defender.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Wallach, we would waive any further reading of the complaint. My client stands mute and we would ask for an adjourned pretrial date, please, Your Honor.
Defendant having waived formal reading, standing mute. The court will enter a not guilty plea. Pretrial in this matter will be adjourned to
October 15th.
October 15th, 2025, 9 a.m. As to bond in this case.
Your Honor, in this case, the people are just requesting no go to Meyer stores and standard misdemeanor bond conditions.
Thank you.
Not sure how long she's planning to be held at Monroe, so I'm not sure if we should do a cash bond or not.
Ma'am?
Yes, sir.
You're currently in the Monroe County Jail. Do you have an expected out date?
October 23rd.
Okay.
I've been here for about 6 months.
All right, and that, at that point, you will finish a sentence, is that the case?
Yes, sir.
All right. What I will do is I will set her bond at $1,000, 10%, so she's getting some credit for what she's there for. I'll order standard conditions, including no assault behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drug. She is not to enter any minor store in the state of Michigan.
Your Honor.
Further comments?
No, Your Honor, thank you.
Thank you, Your Honor.
Thank you, Ms. Wallach.
Thank you.
Court does call the case, People versus Brandon Bobie.
Ashley Beltis for the people.
Good morning, Your Honor. David Chan on behalf of Brandon Bovee is approaching the stand.
Your name, sir?
Brandon Bovee.
Okay. What are we doing?
This is the time and date set for a pretrial, Your Honor. We're trying to get Mr. Bovee into treatment court in Lenawee County. We're waiting for a spot to open. So if we could have like a 30-day adjournment. And I think the spot is going to open because I believe we have somebody coming from there, coming here into 14th District Sobriety Court.
That October 14th. 15.
1-5.
What did you give me last? 15? October 15th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. I believe you received the community corrections compliance.
He got his warning, and it was very clear and unequivocal if he has a missed test or a late test again, that he will be spending his time incarcerated.
And I know you explained to him that I only give one warning.
And he has had his warning.
All right.
Thank you, Your Honor.
Court does call the case, People versus Lawrence Pack.
Ready, Your Honor.
Ashley Beltis for the people.
Your Honor, good morning. Joe Simon on behalf of Mr. Peck. State your name. Go ahead and state your name. Lawrence Peck.
Thank you, sir.
Your Honor, we're here for an arraignment. With respect to that arraignment, we waive formal reading and stand mute.
Defendant every way formal reading standing mute. Court will enter not guilty plea.
And Your Honor, you may remember we were here last week for a PCC. This was probably supposed to be I shouldn't say supposed to be, should have been a companion matter to that matter. We adjourned that to October 9th so my client could be screened for sobriety court. And I'm asking to adjourn the pretrial for the same purpose. He's actually underway. We thought it was going to be a 14A court, but sobriety court, but because of his residence, it's 15th. So he's already made his arrangements. He's going to be screened by 15th District Court. So asking for an adjournment to maybe line up similar dates.
And he's set for October
9th.
Gotcha. You want, so the date after that would be October 15th. That would work.
Terrific. Thank you.
No objection, that's all correct. People like to be heard on bond.
All right. Pretrial in this matter will be adjourned October 15th, 2025, 9 a.m. As to bond.
Your Honor, this is an OWI case. Charges an OWI second offense. The prior is from 2023. There was no crash, but there is that prior. There, the alleged BAC in this case was 0.084. We are requesting electronic monitoring of some kind, given that this is the second offense in 2 years. The reason that there's a companion felony case as well is that there's some RNO attached to the OWI, but we waited for blood to come back on the OWI. So the other business directly got charged first, and then this case is at the same time.
And he's not on any testing on the felony.
Not that I'm aware of.
No, he has been screened and assessed. He's done his aftercare, but I told him to fully expect a referral to community corrections today. He's prepared for that because he's been abstinent, requesting a sober link, Your Honor.
All right. Bond will be set in the amount of a personal recognizance, $10,000 bond. I'll order standard conditions, including no assaultive behavior, possession of any weapons. I'll order there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
I will order also that the defendant report over to community corrections for placement on a sober link testing device. That'd be 3 times a day. And I've signed that order.
Thank you, Your Honor.
And I'll have him head there directly, Your Honor. It'll take a little bit, I'm sure, but I'll have him do that while he's here.
All right, very good. All right.
Thank you, Your Honor.
Court does call the case of the people versus Jason Eckley.
Ashley Feltus for the people.
Good morning, Your Honor. Robert Goldman, P81222, appearing on behalf of defendant Jason Eckel. Your Honor, defendant is appearing by way of Zoom this morning.
Mr. Eckel, can you state your name, please?
Jason Eckel.
All right, got him. All right.
Thank you, Your Honor. This is a date and time separate for pretrial. I've had an opportunity to speak with the prosecuting attorney again. At this time, Your Honor, we've provided to the court a form requesting a final adjournment in this matter. We'd be asking the court to set this for a final pretrial conference. We are continuing to engage in deviation mitigation discussions in furtherance of reaching a resolution. If the court could schedule a final pretrial, we should be prepared by that date. If the court is inclined to set this for October 15th, that does work for defense counsel.
Jury final settlement conference will be set for October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025 at 8:30. Both of those proceedings are in person. Bond will continue.
Thank you, Your Honor.
Thank you. And just to confirm, Your Honor, you said October 17th?
Yes, the Friday. That's a final settlement conference day.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Melissa Hatfield.
Ashley Feltus for the people.
I told you Mr. Bird would show up. No, he's gonna be late, but I don't know. I didn't expect that late. But anyway, go ahead.
Good morning, Your Honor. Tina Saxon on behalf of Ms. Hatfield, who's standing to my right.
Your name, ma'am?
Melissa Hatfield.
Thank you. All right, what are we doing?
Your Honor, we're asking for adjournment. I just learned that there are 2 other videos that Ms. Feltes is going to try to get for us.
Correct statement.
That is correct, Your Honor.
October 15th, 2025. 9 a.m. bond continued.
Thank you, Your Honor.
Thank you.
All right, well, bonds continue to continue. We'll come back to him in a while. Let's go to Wade Mercer down in Florida. We'll see what's going on there.
Señor López, yo soy Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me escucha?
Sí, señor.
He can hear me, Your Honor.
Thank you. Mr. Lopez, you're back this morning to try to see if we can resolve your pending charge in 24-274 MM.
Señor López está de vuelta hoy para ver si podemos resolver su cargo pendiente en el 24-274 MM.
Mr. Lopez, you are accused in that case with 1 count of 3 counts. What is the charges? I don't see them on here. Okay, I see them now. Thank you. You're accused of 1 count of no valid driver's license, 1 count of leaving the scene of an accident without giving appropriate information, and resisting an officer without violence.
Señor López, a usted se le acusa, tiene un cargo de manejar sin licencia, un cargo de abandonar el lugar de un accidente sin dejar la información apropiada y un cargo de resistir a un agente del orden público sin violencia.
In addition to that, you have a warrant from the United States Immigration Service, not a detainer, but a warrant.
Adicionalmente, usted tiene una orden de detención, no solamente orden de retención, sino orden de detención de parte del Departamento de Inmigración de Estados Unidos.
I am appointing the public defender's office to represent you on the local charges and ask that you listen to Mr. McDaniel.
Le voy a asignar al abogado de oficio para que lo represente en los cargos locales y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Lopez in 24-274 MM. He's going to enter a plea of no contest to the charges as listed.
Su señoría, he hablado con el señor López en la causa 24-274 MM. Él va a contestar no me opongo ante los cargos, así como se les acusa.
understanding he'll be sentenced to 90 days in the county jail, 6 days jail credit, $408 fine, which he'll work off while he's at the jail, or it will become a civil judgment.
Entendiendo que se le va a condenar a 90 días en la cárcel con crédito por 6 días, $408 de multa que va a trabajar por ellos mientras esté en la cárcel, o si no, se convierten en un fallo civil.
He's waived his right to a jury trial and call witnesses at that trial.
Él ha renunciado a un juicio con un jurado y a llamar a testigos en ese juicio.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está, su señoría.
Mr. Lopez, did you hear that agreement?
Señor López, ¿escuchó usted el acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
¿Para cuándo pasan las migraciones?
When would immigration come by?
Immigration will typically, let me start over. The jail is going to notify immigration when you get near the completion of your sentence, usually when you have around a week left.
La cárcel notificará a inmigración cuando usted esté cerca de completar la sentencia, cuando le quede más o menos como una semana.
Immigration would then pick you up and you would go to whatever process you're going to go through with them after that.
Inmigración entonces vendría a recogerlo y usted pasaría el proceso que va a pasar con ellos después.
Do you have any other questions?
¿Tiene
¿Y
alguna
el
otra
trabajo
pregunta?
de qué trabaja si acepta trabajar
And work,
mientras cumpla mi condena?
what work is there if I agree to work while I do my sentence?
You may get additional time off of your sentence and finish your local sentence quicker than 90 days.
Quizás pueda recibir tiempo favorable y trabajando terminar la condena más pronto de los 90 días.
You have at most 84 days left, but you may do somewhere closer to 70 days, perhaps even a little lower if you get in the trustee program.
Le quedan como 84 días, pero quizás lo pueda reducir a 70 o quizás menos si entra al programa del fideicomisario.
Any other questions?
¿Alguna otra pregunta?
Sí, es todo, yo puedo entrarlo.
Okay, yeah, I can go into it.
Okay, you do want to enter this plea, correct?
¿Quiere aceptar este acuerdo, correcto?
Sí.
Yes.
Mr. Lopez, I'm going to accept your plea of no contest to those 3 charges.
Señor López, acepto su contestación de no me opongo ante los 3 cargos.
I want to judge you guilty of those offenses I want to judge you guilty of those offenses and sentence you to 90 days in jail on the first-degree misdemeanor, resisting.
Lo voy a condenar culpable y lo condeno a 90 días en el delito menor en primer grado, resistir.
60 days jail on the other 2 charges, but they're all running concurrently, which means 1 sentence total.
Y 60 días en los otros 2 cargos, pero todos son simultáneos, así que todos transcurren a la misma vez.
$408 court costs and fines and credit for 6 days that you've already served.
$408 en multas y costas y crédito por 6 días que ya ha cumplido.
If you get the court costs and fines worked off, great. If not, there'll be a civil judgment against you for that amount.
Si puede trabajar a cambio de las multas y costas, qué bien, pero si no, será un fallo civil en su contra.
And I'm going to ask the jail to go ahead and turn you over to ICE when you get near the completion of your sentence, if they still want you, that is.
Y le voy a pedir a la cárcel que lo entregue con inmigración cuando se esté acercando al final de su sentencia. Eso es en caso de que ellos todavía lo estén buscando.
Do you have any questions, sir?
¿Tiene alguna pregunta, señor?
Son 90 días por toda el carga.
So it's 90 days for all the charge?
Yes, it's 2 of them carry a maximum sentence of 60 days. So you got 2 cases where you're sentenced to 60 and 1 you're sentenced to 90.
Sí, entonces son 90 días en total. Tiene 2 en que está condenado a 60 días y en 1 está condenado a 90.
But they're all running at the same time. So essentially, the longest sentence is the 90-day sentence.
Pero todos son a la misma vez, así que básicamente la sentencia más larga es la de 90 días.
You have 84 days left at most, and it's certainly possible you'll do less than that.
Le quedan como máximo 84, pero es muy posible que termine cumpliendo menos de eso.
Any other questions?
¿Alguna otra pregunta?
¿Para cuándo empieza el trabajo?
When does work start?
Talk to the jailer after court and tell them you would like to participate in the trustee program.
Hable en la cárcel después de la audiencia y dígales que usted quiere participar en el programa de trabajo, Trustee Program.
Corporal, do they still do that intake people on Thursdays?
Sir, what do you mean intake?
That's when they would evaluate people for the trustee program was on Thursdays. Is that still the case?
Oh, no, it's any day, Your Honor. Just as long as they've been seen by the doctor, they've been sentenced and cleared by medical, I can make them a trustee.
So let Mr. Ricardo, please let him know, as long as he's cleared by medical and seen by a doctor, hopefully he'll be a trustee the next few days.
Sí, en cuanto el personal médico lo evalúe y le dé el visto bueno, puede entrar en el programa en los próximos días.
Gracias.
Thank you.
De nada. Have a good day.
Bien, que tenga buen día.
Gracias, Señor Ricardo.
Thank you, Your Honor. Have a good day as well.
You too. Bye-bye. All right, ladies and gentlemen, now we've got some people that have friends or family in the courtroom. So let me see who's on the list. At the top of the number 2 on the list has friends or family. That's Alice Custer. Let me see Miss Custer next. Miss Custer, your mother, your daughter, and your sister are all here in the courtroom. You're accused of one count of obtaining groceries with intent to defraud. Miss Custer, there is probable cause in that case, ma'am. I'm going to appoint the public defender's office to represent you for first appearance purposes. Listen to Mr. McDaniel. He's going to tell me if there's a bond analysis needed or if there's a plea agreement reached. Mr. McDaniel. Your Honor, we just asked for bond. And Mr. Mitchell, anything from the state?
Not this time, Your Honor.
Ms. Custer, I'm going to set your bond at $2,500 cash or surety. Ma'am, you have the right to post the bond. If you post the bond, you'll be released. It's a cash or surety bond, which means you can go through a bondsman if you wish, and you will get used the phone after first appearance, ma'am, to try to post the bond. The other thing we're going to do is go ahead and give you a notice for your court date, Ms. Custer. That way we'll know that you get your notice. We don't have to mail you one. We'll know that you have it. When will that be, Dawn? September 29th. And there's a condition, no contact with the alleged victim. I think this was perhaps a church that's accused of this defrauding in Sneed's area. No contact with that institution while this case is pending. Let me make sure about that. You look like you may be a little confused and your family has the same questions. I think it was something to do with getting allegedly getting some type of card from a church to buy groceries and then coming back and saying that it was not valid, but the card you allegedly gave back to them was one that had been used a month or two before then, not the one they had just given you. So let me see what church or program it was.
Looks
so
like
you'll know who to have no contact with, Mr. Mitchell.
looks like Sneed's Assembly of God
Yes.
is where they got a food voucher from.
So no contact with Sneed's Assembly of God. Now, if they want you to come to church there, I have no problem with that. But unless they want you to, if they want you to, you notify the probation office so I can amend this condition of
It's
your bond.
definitely a misunderstanding.
Okay. All right, we'll give you obviously got a chance to get it figured out. You post the
Yes,
bond, you'll
sir.
be released.
Is
Mr.
my
McDaniel,
family gonna post bond?
I think Mr. McDaniel has a request. Listen to the attorney first. There may be a little bit of
Yes, sir.
money that might be, if she's guilty, this might be owed. You might want to, do you want to consider a cash bond? Mr. Mitchell?
I got no objection.
Would you prefer, or would your family prefer a $250 cash bond? A cash bond, without having to go through a bondsman. Your sister, correct? Your sister says if I set a cash bond, she can post that after lunch, and Mr. Mitchell's not opposed to that. So I'm going to set a $250 cash bond. That way you don't have to go through a bondsman. The amount she allegedly got through this card, I think was $100, but you know her criminal history is probably better than I do. Ms. Custer, your sister says she's going to try to get you out of there after lunch. Any questions?
Whatever my check is, but I'll be there today.
Okay. Any questions, Ms. Custer? Any questions from the family? All right, thank y'all for coming. The next case that has friends or family here would be Ms. Barfoot, Marlene Barfoot. Ms. Barfoot, good morning. Ms. Barfoot, your husband's in the courtroom, ma'am. You're accused of one count of violation of injunction for protection. Ms. Barfoot, there is probable cause. In that case, I'm going to appoint the public defender's officer to represent you for first appearance purposes and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with Ms. Barfoot. We're just going to ask for the court to consider a cash bond. She has strong local ties, owns a house and lives in the community, works, and she's not going nowhere. She has, I don't think, any criminal history. If she has anything, it's not much, if I recall.
Yeah, she doesn't have much. 2016 battery charge that was dropped. 2019 DUI. Possession of controlled substance without a prescription. I think that may be it.
I did have a prescription, I just didn't have it with me, sir.
Okay. Mr. Mitchell, any input from the state?
No objection to a cash bond. We just obviously say request that she have no contact with the victim in this case in any way, shape, or form.
Ms. Barfoot, I'm going to let you pick between a bond and a conditional release because your history is not bad and it's a misdemeanor charge. If you want to accept the conditional release, that's fine. If you prefer the cash bond, that's fine. Ma'am, your cash bond is going to be $250 cash if you choose the cash bond. Ms. Barfoot, there's a condition of no contact with the alleged victim. It appears the judge has already ordered that. The allegations are, don't comment on this. I just want you to understand the allegations are that you allegedly repeatedly continue to say or do things. I think this may be a neighbor.
Correct.
And some of this is supposedly captured on video. So ma'am, when I say no contact, I mean, don't have anything to do with her. Don't say anything that could possibly be interpreted as directed to her. Have no contact with her. Don't even look. I guess it's a her. I think it may be a female. Don't even look at that person, Ms. Barfoot. I need you to understand you're entitled to a bond. Even though you're accused of violating the judge's order, you're entitled to a bond legally. That's why I'm setting you one. If there's allegations you have any contact towards her from this point forward, you will not be entitled to a bond at that point because I will likely revoke your bond and you'll be in jail with no bond. So no contact means no contact whatsoever. The injunction is still in effect as far as I know. Ms. Barfoot, do you have any questions?
No, Your Honor.
Sir, do you have any questions? So ma'am, as soon as the $250 cash is posted, you'll be released. I'm going to ask the jail to give you a notice for your next court date, which will be September 29th at 9 a.m. You will not get a notice in the mail. The notice they're going to put in your hand will be the only notice you get. September 29th at 9 a.m. And we'll see you on that court date. Okay, ma'am?
Yes, sir. Thank you.
Yes, ma'am.
Is that what she chose, cash bond?
She chose the cash bond. Okay. All right, that takes care of everyone that has friends or family here. So we can go back to the top of the list, which is Daniel Hedges. Thank you.
Morning, sir.
Mr. Hedges, good morning. Mr. Hedges, you're here because you've been accused of 2 charges. You've been accused of 1 count of using a computer device to solicit a minor to engage in unlawful sexual conduct, and 1 count of unlawful use of a 2-way communication device to further the commission of a felony. Both of these are 3rd-degree felonies that you're accused of. Mr. Hedges, there is probable cause for the charges in the complaint. Mr. Hedges, your criminal history is not bad. 2016 marijuana-related charge and allowing an unauthorized person to drive at some point. And that's it, I believe. So, Mr. Hedges, I'm going to listen to the attorneys and I'm going to address your bond status. Mr. McDaniel, anything from the state?
No, Your Honor.
Mr. Mitchell?
Your Honor, I don't know what his occupation is, but this is very similar to a lot of the other cases that we had that's come in here. Those same conditions that they got was no unlawful use of the internet. So we would request the same for Mr. Hedges in this matter.
Was the condition no unlawful use or no use?
It may have been no use. It may have been no use.
No use. So, Mr. Hedges, Judge Garcia first appeared 7 of these type cases Saturday, Sunday, and Monday of last week. There's significant difference. The difference is those cases all had an additional charge because they allegedly completed the act of traveling to the location. You're not accused of that. The allegation against you is you had this communication. You agreed to meet this person you believe to be a minor, but you never followed through with it. So you have one less charge than they do, which means your bond's going to be less than them. So I'm going to go ahead and set your bond at $5,000 on each of these charges. You're accused of 2 third-degree felonies. Your total bond is $10,000. It's cash or surety, Mr. Hedges. Cash or surety means you don't have to come up with all $10,000. You do have a condition to have no contact. Excuse me. You have the option of going through a bondsman, and what that bondsman charges you will be up to you and the bondsman. Mr. Hedges, when I looked at the files this morning, because I wanted to know what bonds Judge Garcia had set, because I wanted to be somewhat similar, but obviously they're slightly different because of the different charges. I noticed that she did 2 conditions in just about every case. Every case I looked at, she did no internet use and no unsupervised contact with any minor. So first of all, let me ask you, your pretrial release sheet doesn't show a job. Are you employed in such a way that the internet's a necessary part of your employment?
No, sir, I'm not employed at the moment.
Okay. Do you have any minor children or other minors that you're around regularly, such as relatives?
No, sir.
Okay, so you're going to have 2 conditions to your bond. One is no internet use at all, and the second one is no unsupervised contact with minors while this case is pending. You will get to use the phone in just a few minutes, sir. You post that bond, you'll be released. I'm going to ask the jail to give you a notice for your court date. For Judge Garcia, that's who you'll be appearing in front of, and that will be
October 7th.
October 7th at 8:30 will be your notice. They'll put that in your hand before you leave the jail. You have any questions?
No, sir.
Judge, my only concern is I wouldn't move Judge Garcia. I don't recall her doing that, or anything, but I mean, it's,
I'd say Oliver is an example of that right there.
it's almost impossible not to use I mean, it's on your phone. Some things have to be paid online, but through bill pays and other things, it's almost impossible. It uses the internet when you send a text message. The internet is used when it uses a text message. I mean, it's going off through the internet. So it's almost impossible. It's not like it was 20 years ago when you, I mean, it's kind of, when we say no internet, that's almost an impossibility to comply with.
Mr. Mitchell.
Your Honor, my basis is that it's a very similar charge to what those others received, and they received the same conditions on top of that. So that's my basis for it.
Mr. McDaniel, I'm considering a condition, an exception to bill pay and texting.
That's, I mean, we just have to realize that everything's on the internet now.
So-
The phone service goes through the internet. I mean, everything goes through the internet, and
Some phones go through the internet if you have Wi-Fi enabled telephone calls.
MSN messages are all internet based.
So I'm not talking about text messaging, and I'm not talking about, that's an exception to my condition. And also I'm not talking about bill pay. If you pay bills, I pay some bills online. If you pay bills online, you're allowed to do that, but no other internet use other than those 2 areas. Any questions,
Correct.
sir?
No, sir.
Wish you the best, Mr. Hedges.
Thank you.
Yes, sir. After Mr. Hedges, we have Sarah Now.
Morning.
Ms. Nowell, good morning. Good morning, ma'am. You're here because you're accused of 1 count of child neglect. Ms. Nowell, there is probable cause in the complaint for your case. Ms. Nowell, your criminal history is not bad. There's 1 prior driving license suspended charge on here. That's all that I see. Ms. Nowell, the concern is that this appears to be, according to the complaint, this appears to be a reoccurring issue. So I want to set you a bond, but I've got to figure out the conditions on limiting contact and how to do that. And I have no idea where the child is at now. Mr. McDaniel, any input you have?
Your Honor, I did not get a copy of the complaint this morning for her, so I've seen that she had very little history, so where's your child at now, ma'am?
He's at my house with my mom.
So y'all live together?
Yeah, she lives with me.
And is DCF involved in the case, or?
I don't think so.
So
They almost had to contact Department of Children and Families. Surely law enforcement, they find a child in the middle of the road. Surely they would contact law enforcement. Mr. Mitchell, do you have any idea?
I've got nothing.
Did you see the complaint in this case?
She said they called them.
Go ahead.
She said
ma'am.
they called and they said it was okay for them to stay with my mom at my house.
Mr. Mitchell.
Hold on just a second, Your Honor. Check it.
It's not in there.
I was about to say, yeah, there's no complaint for Ms.
Well,
Now in
it
here.
just, they just,
Yeah.
jail just forgot to send
I
it.
don't know what you say. When you say in here, I have no idea what you're talking
In
about.
the first appearance
So
paperwork.
when the jail sent you both emails, today's paperwork, they didn't include Ms.
Yeah,
Niles'
no,
complaint?
nothing.
Mistake. It's no big deal, but
Yeah.
I meant to read it when I was at the jail, but I
So
forgot.
that, to summarize the allegations, there's a 5-year-old found in the middle of the roadway naked. The concerning part is the complaint says it's been a reoccurring issue. Last year, the child walked all the way to Dollar General. This is on Panhandle Road, across from where the Oaks used to be. Last year, the child walked all the way to Dollar General, half a mile, and was found. And then at one point, it was found in front of Tractor Supply on Highway 90 with no clothes. This was, these are all, I'm just telling the allegations in here. I don't want you to say anything that's going to hurt you. Those are what she,
No, I'm
that's
saying
what
that
they're
was the
saying.
same
So,
day.
oh, was it the same day? Okay.
Yes.
And now there's something else in here. Last week, the child was in her yard at 2 a.m. Now, the complaint does say the child has special needs, which makes things even more complicated. But so there's an allegation of a reoccurring pattern of not supervising the child, which leads law enforcement to the conclusion that the child's endangered, possibly get hit by a car or whatever. In Ms. Now's favor, she appears to be a state employee. Is that right, ma'am?
Yes, sir.
Mr. Mitchell, anything else?
I think maybe we could add a condition to her bond of comply with any DCF compliances. I'm like you said, I'm pretty sure DCF has been contacted regarding this, and they may put in any special plan for her to have contact with this child. So I guess we could just make the condition comply with whatever DCF comes up with.
Mr. McDaniel, anything?
I mean, I would agree with that. I mean, I haven't read the complaint, but I know that special needs kids sometimes can be challenging. It's very difficult for any mother that works to keep their eyes on a 5-year-old 24/7. I mean, it's just difficult.
Ms. Now, I want to put a condition, no unsupervised contact with your child, at least for the time being. And I want to make sure your mother is an appropriate person to supervise. How old is she? Is she retired? Does she work? What's her situation?
She's 49. She doesn't work. She just lives in my house.
She lives in the same home, correct?
Yes.
Okay. So I don't know if DCF is involved. I have no problem deferring to them at some point and letting them decide. But at least for the time being, regardless of what DCF wants for the time being, you're going to have a condition on your bond of no unsupervised contact with this child. That means that if you're there with a child and you're alone, that's a violation of your bond. Someone's got to be there to help supervise this child, at least for the time being. If DCF wants to modify that, certainly can come back to me or Judge Garcia, and we'll consider that. I'm going to set your bond at $2,500 cash or surety because your criminal history is good. But you've got to understand, you've got a serious charge against you that the concern is the health of your child. And it appears that you haven't been able to get this situation figured out. We got to get it figured out. This is not acceptable. What you're accused of is not acceptable. I don't know whether you're guilty or not. I just know the allegations are not good at all. That's very concerning that someone allegedly is not able to maintain the appropriate care for their child. Whether it's intentional or not is not the concern. The concern is the child's safety. Do you have any questions, ma'am?
No.
So you'll use the phone in a few minutes, ma'am. You post that $2,500 bond, cash or surety, you'll be released. I'm also going to ask the jail to give you a notice for your court date. October the 7th at 8:30 will be your court date before Judge Garcia, okay?
Judge, I did tell her that I was going to ask for a cash bond. I don't know if you're, inclined to it. I know that she's, I don't think it's something intentional. I mean,
I don't necessarily disagree with that. It appears to be negligence.
Yeah.
That's what's alleged. Mr. Mitchell, what's your position on cash bond?
I have no objection.
Would you prefer a $250 cash bond so you don't have to go through a bondsman?
Please.
$250 cash bond then, okay?
Thank you.
Have a good day, ma'am. You're welcome. We've already seen Mr. Lopez. We've already seen Ms. Barfoot. Christopher Sin is next. Mr. Sin, good morning. Mr. Sin, you have two matters. You got a violation of probation in case 23-235 CF. In that case, I'm sorry, ma'am. Someone keeps coughing. I can't hear. So if you'll wait outside, when we get to the case you're here on, we'll get somebody to let you know we're going to call that case. Ms. Sin, Mr. Sin, violation of probation has no bond on it. In that case, sir, And you also have an additional hold out of Washington County. The Washington County hold does not address a bond, so you may or may not get a bond when you get there. I want to go ahead and arraign you on the Jackson County violation of probation charge and get you a lawyer appointed if you're asking for one. You want an attorney appointed to represent you in the Jackson County GOP?
Yes, sir.
I'm going to appoint the public defender's office to represent you in the Jackson County charge. Listen to Mr. McDaniel, and then we'll see if you have any questions.
Your Honor, we're going to enter a plea of not guilty. Ask to set this on October 9th, pretrial docket, and advising Mr. Guy Green to come by and talk to him prior to that hearing.
October 9th, Mr. Mitchell, anything?
No, Your Honor.
So Mr. Sin, October 9th will be your court date, and Mr. Green will see you before your court date. Do you have any questions?
No, sir. I'll be able to run everything concurrent because well, I know.
There's no way I can tell you that. There's no way I can predict that. It's possible, but I have no idea, sir.
Yeah, I was charged with something that was not even mine. There's nothing. There's an old burner.
Mr. Sin, just say thank you very much, and I will see you soon. Okay, don't talk about your case.
Talk to your attorney in private. Okay. Have a good day, sir. We have Cleveland Dixon next. Mr. Dixon, good morning. Mr. Dixon, Mr. McDaniel added you to the list today to see if we can make some progress on getting your case resolved. So listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Dixon in 25379 MM. He's going to plead of no contest to the charge of trespass, and understanding he's going to be sentenced to 6 months in the county jail. He'll have 65 days jail credit, $370 fine, and he will be allowed to serve that sentence at Promised Land. And he understands that if something goes wrong with Promised Land, he's going to come back to jail and serve that sentence at the jail. And possibly be charged with escape, correct? Correct.
Mr. Mitchell, is that all agreeable with the state?
That is the agreement. Yes, Your Honor.
Mr. Dixon, did you hear that agreement?
Yes, sir.
Mr. Dixon, do you have any questions about that agreement?
No, sir.
And is this the plea you would like to enter?
Yes, sir.
Mr. Dixon, I'm going to accept your plea of no contest to the charge of trespass. A judge is guilty of that offense in case 25-379 MM. Sentence you to 6 months in the Jackson County Jail, credit for 370, credit for 65 days you've already served, order court costs and fines for $370. I'm signing the Promised Land paperwork allowing you to go to Promised Land. I think you signed this yesterday based on the date. So what that means is, have they talked to you about transport, getting you over there? Who's going to transport you and when? Is it going to be the chaplain or somebody else?
Chaplain. He's going to supposed to take him today.
Mr. Dixon, my understanding is it's supposed to go today. Is that your understanding?
Yes, sir.
Yes, sir.
So Corporal, after first appearance, I'm going to ask Ms. Williams to get this to the jail. This order extending limits of confinement, this needs to go with him. A copy needs to be provided to Promised Land so they'll have it. And Mr. Dixon, if you complete that sentence, then what you'll do is you'll come back to court, put on the record, we'll get your certificate that you completed the program, and that'll satisfy the sentence. If you don't complete the program, there's going to be a warrant issued for your arrest. So, Mr. Dixon, I hope you stay and complete the program, and we see you a lot less frequently in court. Almost every time I see you, it's a trespassing charge, Mr. Dixon. So hopefully this will get that all fixed. You have any questions?
No, sir.
All right. Wish you the best, sir.
Cleveland, stay away from that alcohol, buddy. You hear me?
Yes, sir.
Don't do you well. You understand? I talked to you about this. Now that alcohol don't do you well. You need to stay away
Yes, sir.
from it.
Yes, sir. Yes, sir.
Wish you the best, Mr. Dixon.
I know a lot of people think Florida is weird, and it's hard to disagree with them, but I really like this particular court. I like the way they do things, and I really like Judge Mercer. But that having been said, let's go to Miami-Dade. We're creeping up on the lunch hour. Let's see how Judge Glazer's holding up.
Are you afraid of James Oliphant?
No,
Do you want the court to order Mr. Oliphant to stay away from you?
no,
Do you understand the court cannot protect you against any future violence from him without a stay away order?
I know.
Okay. State any questions?
No questions.
Ms. Corey, any questions?
No, Judge, thank you.
All right. So, sir, I'm going to enter a modified stay away order from the alleged victim, Alexis Gilbert. You are allowed to have contact with the alleged victim, Ms. Gilbert. You are prohibited from being physically threatening or violent towards her in any manner whatsoever. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand this modified stay away order, sir?
Yes, ma'am.
I have a
Thank you.
question.
Yes, ma'am.
We stay in the same home together. Will he be
You
able
two can
to?
live together, no problem.
Okay.
They stay in-
Judge,
That's
it's funny.
fine.
He's on probation.
He's on probation
Actually,
from
you know
when?
what? I don't think he is. It looks like it's a different date of birth. I'm not sure.
I don't think that's, I don't know. Looks
Wait.
like.
I don't know.
It's eligible for trial? Oh, okay. Pretrial services alternate bond, count one will be $1,500 and count two is $1,000.
And Judge, on the order, can you indicate they're allowed to live together?
They are allowed to live together.
Thank you.
Thank you.
Okay, thank you.
Have a good day. Thank you for coming in.
You too.
You want to, they're allowed to live together, please. Next we have is Miguel Ortiz Fernandez, page 10. Bond out.
Bonded out.
Ronell Stevens, page 11.
He was on house arrest and was rearrested on this case. And
Okay.
he was close house arrest.
Hold for F24 19997. Good morning, sir. You were arrested for carrying a concealed firearm. I will appoint the public defender's office for you. So why is he prohibited from carrying a firearm?
Of his age.
Oh, there's probable cause then for the charge. He's out on bond, $2,500 bond. You'll see your judge tomorrow. Have a nice day. Next is Robert Saavedra. Page 12. Good morning, sir. You were arrested for aggravated battery with a deadly weapon and burglary with an assault or battery. This is from October 2nd of 2025. Sir, can you afford to hire a lawyer? Huh?
He doesn't think so, Judge.
I will appoint the public defender's office for you.
Requesting that the defendant be held without bond pending an Arthur hearing.
Very violent. There's probable cause for the charge. You are ordered to stay away from the alleged victim whose initials are JP. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim's home, school, and place of employment at all times. 1 second.
I see no prior history for Mr. Saavedra. Would you consider house arrest for him?
I'm trying to see, what's the burglary with the assault or battery? The victim's in the vehicle while he's beating him with a firearm, the butt of a firearm.
That's the burglary.
They're pulling him out of the vehicle. That's what it is. So there's probable cause. No, this is a non-bondable offense. So count one, aggravated battery with a deadly weapon is a $7,500 bond. Count two, burglary with an assault or battery, that's no bond. You're gonna have to go before the division judge and have what's called an Arthur hearing to see if you can be released from jail pending the arraignment or trial. Your lawyer can set that up. Good day, sir.
Well, I've seen her do worse as lunchtime approaches. Let's go back to Judge Simpson, but I have it paused at the moment because young Ronald Reagan is back. But that freeze frame, it almost looks like a promotional still for young Ronald Reagan's next big hit film. I just thought it was very dramatic looking, so I thought I would share. But let's get on with it. Let's see what's going on.
My initial order will be that you test every other week at community corrections. However, I will allow you to test at an approved facility in Kalamazoo. All right. So you'll be taking a drug test, short form, you'll be taking a drug test every week. All right. And testing every week. All right.
Yes, sir.
Okay. All right. So on the misdemeanor case, you're seeking an adjournment, counsel.
Yes.
I'll adjourn that to October 2025, excuse me, 9 a.m. And as to the PCC, is there a reason that we need to necessarily keep these together at this point, or?
I don't think so, Your Honor.
All right. What date would you like?
A 2-week adjournment or a 3-week adjournment would be great, Your Honor.
All right. My next one's the 18th. What, the 9th?
Sounds good. Thank you.
October 9th. Probable cause conference in this matter will be adjourned October 9th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue in that order, as I've indicated regarding community corrections, is going to be entered in both cases. All right. Thank you. When you leave here, I suggest that you go over to community corrections, check in so that you can do the intake portion. So you're in town. Okay. Thank you.
Thank you.
This is yours. And you just wait. I need to.
Court does call the case, People versus Robert Moyle.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Mr. Silla.
Good morning, Your Honor.
For what?
A show cause for failing to appear for that.
Your name, sir?
Robert Moyle.
And this is failure to appear for arraignment.
For arraignment?
No, hold on a second.
So they said it for a show cause. This is actually a misdemeanor, vehicle misdemeanor category. So they were to respond to the case.
Okay. All right. Sir, you have a citation that alleges that on or about February 20th, 2025 at the location of Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle with an improper registration or plate. You understand that charge?
Yes, sir.
All right. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs.
Yeah, I thought I would.
Understand that?
Yes, sir.
Okay, I don't want you saying anything about the charges. You're in custody now on something else.
I was coming for sentencing today. That's what I thought this was. So I was totally thrown off just now by you saying that.
Who are you going to be sentenced by?
I was under Colleen. Had a car accident, I do believe. So I wasn't for sure who the judge was going to be today. But I have sentencing today. I thought about
Conlon.
Conlon.
So, okay,
Yeah,
so you'd be downtown.
Yeah,
Oh,
see,
but-
it threw me off this morning. Yeah.
Right, okay. So are you represented by the public defender in that case?
Yes.
Do you wish to be represented by the public defender in this case?
I don't. Yeah, it's probably gonna be time served with what I got going. I would imagine. I'm just took a plea for a
Well,
year.
I'm not promising.
Okay.
sentence.
Yeah, right.
So
Yeah.
I
I
also
will.
don't know if you're being sentenced on a felony.
No.
You
Yeah.
might want to be careful as to whether or not this does something to your guidelines.
Oh. Okay.
So I'll ask you again, do you want to be represented by the public defender's
Yeah, that's
office?
best.
Yeah, good answer.
Yeah, I think it's best.
Public defender case.
Public Defender Natalie Pate with and on behalf of Mr. Moyle, we would waive any formal reading of the complaint. My client would stand mute and we would ask Your Honor for an adjourned pre-trial date. And that would be all.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be adjourned to October 15th, 2025, 9 a.m. set his bond in this case at $1,000. I'll give it $1,000, 10%. Depending on what happens in the other case, you can let the court know. I'm just setting a nominal bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. All right, thank you.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Court calls the case of the people versus Salvatore Lorenzo.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Lorenzo, who's up there on Zoom. Sal, could you please state your name for the court?
Salvatore Lorenzo.
And I don't know if he's been arraigned yet, Your Honor.
He has not.
Well, as far as I go, ask the court to please waive reading, and he stands mute.
Defendant having waived from a reading, standing mute. Court will enter not guilty.
As to the pretrial, I sent Ms. Feltus a letter. I think she's looking into it, and we're talking about a resolution, and just need a couple of weeks to work that out, Your Honor.
What I will do is I'll adjourn the pretrial in this matter to October 15th, 2025, 9 a.m. Set his bond in this case at a $5,000 personal recognizance bond, standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. What was the BAC in this case?
0.168, Your Honor.
Any crash?
My notes have eluded me. I just have 1 second.
Yes.
Your Honor, there was not a crash in this case. The defendant was stopped driving on a flat tire.
All right.
But I would note for the court, there is a count 2 of attempted assaulting, resisting, or obstructing a peace officer attempt.
Understood. So just so that we're clear, I'm going to set his bond at $15,000 personal recognizance bond. I will order that the defendant report over to community corrections for a placement on the sober link testing. I've signed that order.
That's good, Your Honor. We've talked about that, anticipated. He's taken a number of proactive steps in the case so far. So,
all right.
Thank you, Your Honor.
Thank
All
you,
right.
Your Honor.
Thank you. Court calls case people versus Gary Neptune.
Ashley Feltus for the people.
Nalepka.
Sam Bernstein for Mr. Nalepka, Your Honor. Nalepka, can you say your name for the court?
Gary Nalepka.
Your Honor, we're asking the court to please set this for a final settlement conference.
Jury final settlement conference will be set for October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025, 8:30.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case of the people versus Ontario Robinson.
Feltus for the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Robinson. Ontario, can you please say your name for the court?
Ontario Robinson.
Thank you.
Your Honor, in this case, my intent is to file a motion challenging some evidence. I'm wondering if the court has specific days that it prefers to hear such motions.
How long will it take? It's a motion to suppress.
Correct, Your Honor.
All right. When can you have the motion filed?
Within the week, Your Honor.
All right. All right. You are filing a motion to suppress by the, oh, I'll give it a week, by the 24th. Prosecutor's response will be due by the October 2nd. I'll set an evidentiary hearing if necessary on that matter. I'll set an evidentiary hearing for, I'm gonna need a Monday.
You're gonna need a Monday.
And I'm out one. It's gonna be the 20th.
That's jury selection in the morning, so we could do like 11 a.m. that morning.
11 a.m. So an evidentiary hearing for October 20th, 2025 at 11 a.m.
Thanks, Your Honor.
I may have a jury trial that day, Your Honor. I may not. I'll just
Tuesday here, isn't it?
My jury trial? No, it's a circuit court matter.
All right, well,
It's being a conflict. Reach out to me.
Okay, thank you. Makes sense. All right. Oh, one more thing. Sorry. A lot going on this morning. Mr. Robinson is asking that the court would please grant a travel request. He's hoping to go to Ohio from Friday of this
God's
week.
sakes, why?
I
Go
know.
ahead, I'm sorry.
I tried to counsel him out of it, Judge, but I was unsuccessful. So he's consistent. But he'd be very much appreciative if the court would allow him to travel to Ohio from Friday to Sunday.
Of this week?
Yes, Your Honor.
For what purpose, you said?
I think his girlfriend has planned a trip for him there. He's on a SoberLink device. You can, of course, bring it with him.
Any objection for the defendant may travel to Ohio. When will he be coming back?
Sunday.
Sunday afternoon, Your Honor.
So the 21st. So he can travel from the 19th to the September 19th, 2025 to September 21st, or yes, 21st, 2025. That's inclusive.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Jacqueline Murray.
Edward Drugas for Jacqueline Murray.
Your name?
Jacqueline Murray. Mr. Lucas and I had occasion to discuss this case this morning, and I think we're hopefully getting close to a resolution. I understand Ms. Murray is about to be sentenced into the 14B recovery court with Judge Washington
Okay.
in the next couple of days. So what I'm requesting is that we adjourn this to give her a chance to do that, see how it goes for a little bit, looking at that October 15th date. And I wondered if the court would consider, if Judge Washington releases her, just letting your bond convert to a PR to let her get out.
I will adjourn the matter to October 15th, 2025. I understand that. If Judge Washington releases her, counsel is to let this court know, and then we'll take the appropriate action at that time.
Thank you.
Okay, thank you.
Thank you, Your Honor.
Thank you. Court calls case people versus Keyshawn Jorgensen.
Ash Feltus for the people.
Good morning, Your Honor. Charlotte Stefan on behalf of Mr. Jorgensen. Your Honor, I believe he's on Zoom.
Sir? Need to
Hey, how
state
you
your
doing?
name and get someplace at your stationery, please.
Yes, sir. My name is Keyshawn Jorgensen. I apologize. I'm at work, but I'm working over here right now. All right, I'm good.
Okay. All right, what are we doing?
Your Honor, he'd like to take it to trial, and so I would ask for trial and a final pretrial.
Final pretrial. Then. Jury final settlement conference on this case will be October 17th, 2025 at 9 a.m.
Your Honor, I'm out of town that day.
Are you going to be out of town Monday if that's jury selection?
No, I'm not. Monday, October 20th. I'll be in
Yeah,
town.
so here's what I'll do. I'll put jury selection October 20th, 2025, 9 a.m. Otherwise, I don't get this tried to December. So I'll set the October 17th date. He'll need to be here, right? However, get with my office regarding whether or not you can appear via Zoom during that day. That will work for you, or that doesn't work either.
Are there any other days?
No, that's the problem. Otherwise, I do something else for you. Counsel approach me.
Okay, well, he does that and then prepares to continue another bond. Let's go spend some time with our friends in Louisiana.
Is at the Franklin Parish Detention Center. With the staff at the facility, please introduce yourself for the record.
Mr. John, you want the staff to
She wants the staff to introduce themselves.
They want staff. You want staff?
Yes.
All right. Lieutenant Roberts, Franklin Parish Detention Center.
Okay. Right. All right. Please introduce yourself, Mr. Swazer. State your name and DOC number for the record.
Sure.
Jerry Jermaine Swayzer, DOC number 494646.
Okay, thank you very much. Today you are here for a parole revocation hearing. Do you have the questionnaire that you signed?
Yes, ma'am.
Do? Okay, according to this questionnaire, you are not eligible for appointed counsel. Did you have your own attorney?
No, ma'am.
No, okay. All right, so we're going to go ahead with the revocation hearing. Ready?
Yes, ma'am.
Okay. All right. Rule number 1 is that, rule violation number 4, you engaged in criminal conduct evidenced by your arrest on 5/2/2025 for the offense of simple criminal damage to property, driving while intoxicated, first offense, no insurance, driving under suspension, and reckless operation of a vehicle. You can plead guilty, not guilty, or guilty with a statement. Which do you plead?
Not guilty.
Not guilty. Okay. I'm going to be handling your case today. So you and I are going to be talking about this. All right. So you're pleading not guilty.
Yes, ma'am.
I have, can you explain to me what happened that you got all of these charges?
See, I just I dropped my girl off from at work, and I pulled up to my mama's house, which is the house I hit the pole in. I really forgot to put the car in park because it's a new car. My girl just got the car that like 2 days of that day, and I forgot to put the car in park, and it hit a pole. I paid for the pole in my mama. It was in my mama yard. I paid for it, and I paid for the car to get fixed. I wasn't drunk. They dropped the DWI because I wasn't drunk. I just got some new medicine from the doctor. Dr. Abraham, he just gave me some new medicine, and it was stronger than my old medicine. So that's all it was. I wasn't drunk or none of that. On no drugs or nothing.
Well, that's drugs or medicine if it impaired your driving. So you went to court, right?
Yes, ma'am.
I've got that you went to court. I've got also that you were convicted of the simple criminal damage to property, reckless operation, driving under suspension, no vehicle insurance, and then also a failure to appear. So that's what I have that you were convicted under. And it's true, they don't mention the DWI.
Yes, ma'am.
So you were convicted of those.
Yes, ma'am.
Okay. All right. Does anyone have any questions?
Yeah, you said it was a new car?
Yes, sir.
And you didn't have insurance on a new car?
No, I had insurance on it, but I don't know why it didn't swap over. See, she traded her black Chevy Sonic in for a new GMC Terrain. And when she left the dealership, it was brand new. When she left the dealership at Sango in Winsboro on Highway 15, they told her the insurance should be switched over. And it never switched over. It was 2 days later and it never switched over. But when she did switch it over, I got her to take it to the courthouse to show them that she had insurance. They said, never mind.
You have proof of insurance of that date when you actually
Yes, sir.
Okay. So that's what they're saying, reckless driving.
Yes, sir.
Okay. How long have you been out on parole?
I got out on parole March the 10th. I had a job and everything. I was really doing good for myself.
Mm-hmm. And you didn't have any, well, you say you didn't have any alcohol. You weren't drinking?
No, sir.
Okay. So it was just an accident, what you're saying? with the car in the form.
Yes, sir. That's all it was, accident.
And you can show proof of insurance that day that you had insurance on the car.
No, sir, not the day that they towed the car and stuff, and the day I came to jail, I couldn't I didn't the insurance that they was showing and they pulled up on the phone that it had, it was still on the Sonnet. But when they went on and changed it right, I took it to my girl took it to the city police station, and they showed it that it had insurance on it. So I told them to take it to the judge, but they were like, never mind.
So what I'm saying is, you had insurance the day you had the car. Normally they won't sell you a car unless you have insurance on it.
Yes, sir.
Yeah, so you had insurance that day. Okay,
Yes,
I have questions.
Do you have any questions? No. I do have a question though. You were convicted, so you went to court, right?
Yes, ma'am.
Okay, so it took a while to get to court for these charges, correct?
Yes, ma'am. I've been in jail since May the 27th on these charges.
So when you got to court, they looked at your insurance coverage. By that time, all that should have been straightened out. And if it was actually covered that day, when you went to court, your insurance coverage should have been apparent then, but yet they still found you guilty of no insurance.
Yes, ma'am. They my girl took it up there to the clerk of court. She took it like 2 times actually, because I went to court in July, then I went to court in August. That's when they got rid of it. When in August they got the charges. That's when they found me guilty of it. I showed the insurance and everything.
I'd like to have an executive session.
Okay, we're going to call for an executive session at this time.
Stapleton?
Yes.
Ledoux? Yeah. Tillis?
Yes.
Okay, we're a little bit in the Wayback Machine here, so I can shove us forward past their executive session. There we go. You need to unmute yourself, though, guys. Oh, you've got to be kidding me. Well, we have no idea how that one... No, we do have an idea. Looks like they revoked him. Yeah, because I can see it on the screen here. But they never unmuted themselves, so we could actually hear them say it. Bah, 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 bah. People. All right, let's go back to Dad. Dad will save us.
Stephen Sherg, on behalf of Mr. Hamley. Good morning, Mr. Sherg, and your client. Your name, sir? Okay, I'm just going to ask you to keep your voice up nice and loud for me, if you would, please. First of all, I do need to immobilize that motorcycle. So the vehicle needs to be immobilized. I just want to be clear. Did he already take care of that?
That's good. Yeah, so when I got out, I saw it that hey,
I need proof of that. You can't just ignore the orders.
I like your conversation with the
I need you to go to the Secretary of State.
okay, I'll go there and get some saying that it's not that registered to me.
Got to show the transfer. Defendant has, you can't just ignore orders. I told you to do that by September 17th. Defendant has until September 22nd to provide proof that the motorcycle was sold. So you have to go to the Secretary of State. You understand that, correct?
Yes, sir.
And you have to bring that back here by Monday, all right? All right, counsel, have you had a chance to review the report with your client? Are there any material additions, corrections, or deletions?
No, Your Honor. I
Any?
didn't have a chance to review the report, but there's no corrections or deletions.
Okay, anything you would like to say on his behalf?
Judge, my client is taking this very seriously. He has been going to meetings regularly, as required by the court. He is employed, he takes care of his mother who has cancer. He's the son that's mentally challenged, and he's doing whatever he can to make things work in a positive way. He has no interest in drinking again. He's hasn't violated any conditions of his bond. We're asking the court to follow the recommendation of probation. If any jail time is required, Your Honor, we'd ask respectfully to keep it at the end of the probation period. Make sure he can comply with all the conditions of his probation.
All right. Sir, is there anything that you would like to say?
No.
Am I right that the only thing he had was the 2020? He did have one in Allen Park that was dismissed, it looks like. It was Nollyprost in 17.
That's part of it.
Then he had one in 20 in Wyandotte, the 27th.
That's correct.
Just a little surprised they've got a recommendation of jail. Does he have any other criminal history? He doesn't have any, does he?
Not even a ticket, Your Honor.
Pardon?
Not even a speeding or a traffic ticket, nothing.
All right. If I let everybody finish before I start, I just want to make sure. Okay. 18 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government that will change your address, your place of employment, or home telephone number. You must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs as follows. Submit weekly for 2 months. If you're clean, we'll make it bi-weekly for 2 more months. If you're clean, I'll make it monthly. To continue attending 12-step meetings twice a week in person until you're in outpatient treatment. Once you get into outpatient treatment, and I am ordering outpatient treatment, you do not have to attend AA or NA any longer. You're to attend the Victims Impact Panel. That's one night put on by Mothers Against Drunk Drivers. You're going to continue your SoberLink device on your SoberLink until I'm going to make it December the 1st. You have until September 22 to provide proof that your motorcycle was stolen. I'm going to order that you serve 5 days jail credit. One, I'll let you serve those as follows. 3 days on our court work program. There's a $35 a day charge for that for a total of $105. And 1 day of community service. Community service, I'm going to give you until October 31. So your lawyer will explain that. But any place you have to do your community service at a location that is, it has to be a nonprofit organization, okay? This was a BAC, so cost of recovery is $150. Fines $300, cost $200. $75 victims' rights fee, $50 justice assessment, 6 1/4 screening fee, $60 for 685. You have probation fees of $360 for a total of $1,045. You have cost of recovery, which you'll pay through the court, of $150 for $1,195. Plus, you have the court work program fees. Your total's $1,300. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal, and also you may be eligible for early discharge if you're compliant after half the time, okay? So after 9 months, if you're compliant, no violations within the preceding 90 days. Do you understand everything I've said?
Yes.
Can he pay all of this today, Mr. Shard?
Yes.
Okay, so you pay this now, you'll meet with probation, you fully understand the sentence.
Yes.
Okay. I wish you well. Good luck.
Thank you, Judge.
Thanks a lot. Have a good day.
Let's head to Nevada, Reno, Nevada. This is Judge Shelley O'Neill. We have seen her once a week the last couple of weeks, and we've enjoyed it every time we've been there, and it seems like she only streams about once a week, so let's spend some time.
Hearing in case 25 CR 13415. Just opening my computer now. Just give me a moment. All right, it looks like, Mr. Weber, you entered a plea of guilty on September the 7th, 2025 to the charge of simple battery. The matter was continued to this date to allow the victim to appear. I will note for the record that Mr. White, the victim in your matter, has appeared and is present. So for everyone here involved in this matter, the process is as follows. I will hear from first the prosecutor. He'll go over the facts of the case and make a recommendation as to sentencing. Then I will go to Mr. Loomis on behalf of the defendant to make an argument relative to the defense. Then Mr. Weber will get the opportunity to speak with me. And then lastly, Mr. White, the victims get the last word in any sentencing relative to a crime. So I appreciate you being here today, and we'll move forward in that manner. So Mr. Altum, on behalf of the city, what do you recommend relative to the simple battery plea on September the 7th?
Thank you, Your Honor. It doesn't appear that these two, that Mr. White, who is here present, and the defendant knew each other prior to this. Sounds like the defendant, Mr. Weber, was upset about how long Mr. White was taking at a park public restroom and attacked Mr. White, punched him. Mr. Weber, the defendant, has pretty poor criminal history. Older cases that are kind of a variety of cases, but then he has a felony conviction in 2019 for fraudulent check, and more relevant, he has a 2020 felony conviction for assault with a deadly weapon. He has probation violations on those felony cases. This is a crime of violence, so the city is going to be recommending a mix of suspended time and active upfront jail time to prevent further crime and protect Mr. White, but also, frankly, just punishment for the crime of violence. So the city's recommendation will be for 60 days up front with that criminal history. And we would also ask for an additional 90 days suspended on the condition that he obey all laws and have no contact with Mr. White.
Thank you, counsel. Mr. Loomis, on behalf of Mr. Weber, your client, what would you like to add, sir?
Judge, Mr. Weber is 40 years old. He is a full-time caregiver for his girlfriend, whom is paraplegic and is unable to care for herself without his assistance. He did that free without compensation for a year, but is currently compensated as a full-time caregiver. He's been in custody now for 11 days. So I understand that this is kind of an unprovoked type of crime of violence. He's got some history, but I would ask the court to consider the fact that he's already spent 11 days in custody and perhaps give him another 10 and with some type of suspended sentence with no contact with Mr. White.
Thank you, Mr. Loomis. I'd like to hear from you, Mr. Weber. It sounds to me like you have some other obligations outside of this criminal proceeding. I'm sad that you didn't think about that before this crime occurred. What do you have to say for yourself, sir?
Me and the defendant were trying to use the same restroom. He was yelling at me from inside the door. I handled it poorly when he came out. I was yelling back, and he ended up putting his three-wheel bike so close to me that my fingers got attached to the bike. And he and I were in some kind of tug of war with it, with my fingers in his bike cage, because he has a three-wheel bike with a cage. After that, he was coming in and out of my face, and I punched him. It's very regrettable, and I'm sorry it won't happen again.
Thank you. All right, and I'd like to hear from you, Mr. White, your take on this situation. It's always usually different from that of the defendant.
Mr. White, you're muted.
Yes. So,
Tap on the microphone. There should be a little microphone. There you go.
Okay. Yeah, I had to wait for the little tab to come up to do so.
all right, so Mr. White, wait, before you begin, sir,
Yes, ma'am.
you're required to raise your right hand to be sworn when you make a victim statement. Do you solemnly swear that you will and truly present any kind of evidence relative to this matter as truthful, so help you?
So help me God, I do.
All right, sir, go ahead and begin. But first, would you please state your name so we have it on the record?
My full name is James Thomas White.
Thank you. Go ahead and make your statement. I appreciate you being here this morning.
Not a problem, Your Honor. And my statement is the individual involved in this case has most of the facts correct. But the thing that he didn't understand was when he started pounding on the door at the public bathroom in the park, I was in there taking care of constipation. He kept insisting and kept repeatedly pounding on the door to where I finally started calling out to him, look, I'm constipated, give me a few minutes. When I was able to exit the bathroom, I had my wife's three-wheeled tricycle with me, which has a basket on the back. As I was coming out of the bathroom, he grabbed the tricycle, and yes, me and him had kind of a tug-of-war going on with it. I never saw his fingers caught in the cage. The bike flipped over, all the groceries I had dumped out of the basket, and then he came at me. I didn't do anything to him. He came at me. When he hit me so hard that my nose is now broke in two separate places, and I have a fully deviated septum that's going to require plastic surgery. I understand that he's a caregiver for someone who can't take care of themselves, and I feel bad about that situation. But aside from that, I just want him to be held accountable by the law and to leave me alone. That's all I want.
How old are you, Mr. White?
I just turned 54.
Okay, thank you very much. I appreciate you being here. I'll certainly take your situation into account.
And to answer your question before it's asked, Your Honor, yes, I am a veteran. I'm a Navy veteran who served during Operation Desert Shield, Desert Storm.
Thank you very much. We appreciate your service. And I
No
always
problem.
take that into consideration, Mr. White. So I appreciate you being here today. Mr. Weber, it just sounds like this is certainly unnecessary violence. And obviously, you got really lucky that this case was presented as a misdemeanor, because hearing Mr. White's testimony, I will tell you something. When you break a bone or cause permanent injury to someone, that's battery causing substantial bodily harm, which can be elevated to a gross misdemeanor or felony. You got lucky that it was merely prosecuted as a misdemeanor, thus reducing the opportunity that any judge could have to send you to prison.
Amen.
So I think in light of those factors, the city attorney's recommendation, I'm going to modify that a bit. I'm going to sentence you to 180 days in the Washoe County Jail. That sentence will be suspended for a period of 2 years. I will order that you serve 60 days up front, because I think this was an unnecessary attack on someone, totally unwarranted. And the fact that you injured somebody so severely just over the use of a bathroom, it's not like you were assaulted or you're defending yourself in any way. I'm really disappointed in your behavior, and I'm sad for your girlfriend who needs your service, but you obviously weren't taking that into account when you were beating up on Mr. White. The conditions of your suspended sentence, or when you're done with the 60 days, and I will give you credit for the 11 days you've already served, is that you obey all laws. You have no alcohol or drugs without a valid prescription, including marijuana, during the 2 years of your suspended sentence, and that you have no contact whatsoever with Mr. White. Do you understand what no contact means, Mr. Weber?
No contact whatsoever.
All right, so that means no social media, no going by his home, no going by work, any of that sort of thing. If you violate that, you'll go back and do the balance of the 180-day sentence. Do you understand, sir?
Absolutely.
This is the time that you need to make some changes in your life. You need to act like a responsible adult, that you had somebody to care for and not inflict harm on other people. Do you understand? This person's a veteran. He put his life on the line for all of us in active duty military. And this is the kind of treatment he gets because he needed to use the restroom. That's a sorry state of affairs. Wouldn't you agree?
Yeah.
All
Well,
right.
my was trapped in the bike. I picked it
Well,
up.
the fact that his bike tipped over with his groceries, I think is basically abhorrent. So you should be ashamed of yourself. And I hope that you're a better person when you get out of jail and act more responsibly. You have that in you to be a better person. Let's see if you can do that. Okay.
Yes, ma'am.
All right. That'll be my order. Thank you, Mr. White. You're free to sign off, sir.
Thank you very much, Your Honor, and have a wonderful day.
Yes. And Mr. Altum, did you have something you wanted to say?
No, I was just saying thank you to Mr. White for appearing.
Oh, very good. Now that we've completed that matter, we'll go to the top of the special attention list. And that first person is Yolanda Bonner Carey.
Good.
On our way up.
Very good. Thank you.
Your Honor, you might want to clarify her full name.
Thank you.
Good morning.
Good morning. We have some confusion about your last name. What is your legal last name, Miss Bonner Carey?
My little last name is Bonacari.
And is it BONNER-CAREY?
Yes.
All right. Good morning to you. Your case number, Miss Bonner Carey, is 25 CR 13880. I'm opening up your file now.
Yes, ma'am.
All right, and you were charged on September the 16th, 2025 with trespassing. Did you understand the charge?
I understand it.
All right, and how do you wish to plead to the charge of trespassing?
No contest.
And do you understand by entering a plea of no contest, the court, which is me, will find you guilty of the offense of trespassing?
Yes, ma'am.
Did you understand your constitutional trial rights, Ms. Bonner Carey?
I'm not guilty, though.
Well, all right. So you said no contest. Did you understand your constitutional trial rights?
Yes, I do.
All right. And you understand by entering a plea of guilty or no contest, you're giving up your right to have a trial in this matter?
Yes, ma'am.
All right. And you also understand that this is a misdemeanor offense for which you could receive up to 6 months in jail and or a $1,000 fine.
Yes, ma'am.
And have you served in the United States military, Ms. Bonner Carey?
Yes, ma'am.
And you're a veteran.
I'm a Vietnam vet.
You're a Vietnam War vet. Have you signed up for veterans benefits?
No, not yet. I'm in the process right now. They're helping me now.
Okay, very good.
I'm Troop 103, also 702, 213, and 415, and 203. I'm Troop, all of it.
When did you, what branch of the service did you serve in the military?
It wasn't in a branch. I'm in the Vietnam. I'm an Army brat, but I'm Vietnam vet. Period. I was in the war.
Okay.
Before we pulled the Marines over. I'm active now, only because they pulled us in, because we're at war right now.
Well, I'm aware of that.
Yeah.
All right. I will. I'll go ahead with some. Hold on, Ms. Bonner Carey. Hold on a minute. I want to ask Mr. Loomis a couple of questions. Okay. Mr. Loomis, do you have any concerns relative to Ms. Bonner Carey's competency?
Judge, she said some fairly unusual things to me, and I told her, look, if those are what you're asserting is true, then it looks like you might need a competency hearing. And she responded with what I would characterize as accurate statements, and did not follow through on the unusual statements. I had not heard about prior military service.
All right. So, Mr. Altum, based upon what you've heard, shall we proceed?
It's not my call as far as any of what we just discussed, but she did enter a no contest plea. So it's kind of up to, it doesn't sound like Mr. Loomis is asking for a competency, and then Your Honor kind of makes that final call as well. But with the no contest plea, if Your Honor finds she's okay to go forward, I'm okay to go forward.
Thank you. So, Ms. Bonner Carey, do you know where you are today?
Yes, I'm at the courthouse in Reno, Nevada.
Okay, you're actually at the Washoe County Jail.
Oh, okay, Washoe County Jail.
Okay. Do you work?
Yeah, actually, I'm on disability, but I do work.
And what do you do for a living?
For a living, I'm a crisis advocate and a delective behavior therapist for Reno Behavioral Health. I work with Mark. I'm an advocate. I do crisis for homeless people, and I help them with benefits and human resources.
All right. Well, based upon what I've heard here today, I'm going to go ahead and accept your no contest plea to the trespassing. City's recommendation as to sentencing.
I'll submit it, Your Honor, with the information that she, according to her risk assessment, shows a history of nuisance arrest and failing to handle court matters. She's been in for almost exactly 1 day.
All right. Mr. Loomis, would you like to add something, sir?
Judge, she is 52 years old. She reports being homeless, but she does receive Social Security benefits for disability. I'd ask the court to take those into consideration.
Thank you. So, Ms. Bonner Carey, you're without housing right now?
No, at the moment, unfortunately, Larry with Karma Box, he had been looking for all the homeless people, found. Well, I'm being offered subsidized housing, and the county will be paying for me an apartment. I work with Mary. Mary's over my apartment. She's getting my apartment. Larry's taking care of everything else, and they're taking care of me. We're all working together. So
Okay. Hey, Ms. Bonner Carey, have you heard about our community court down at the library?
Yes, I have.
Okay.
Where I'm going.
Have you been there for services?
No, but that's where I'm going.
Okay.
I have a court date in a couple of days.
Okay, well, it's every Wednesday, and today is Wednesday. So if I let you out today, can you go there next Wednesday to get services?
Of course I can.
Okay, and they can provide food stamps, they can help you with housing.
I already have all of that.
Okay, all right.
I'll still go. I'm looking forward to it.
All right. So what we'll do then is I'm going to sentence you to the time you've already served in custody, but strongly urge that you go over to community court to fill in the services that you need. And it's next Wednesday morning at 9:30, okay?
I also have a conflict of difference from there. You said that's at the library?
Yes.
Okay, the only thing I wanted to talk to her about that, I have a no trespassing. I don't want it to intervene. Can I still go there if I have court, but I'm trespassed from the library? But I want to go to court.
Probably not, if you're trespassed from the library. That's a difficult situation.
That's why I said I've never been there, but I don't even have a crime.
If you've never been there, you couldn't have been trespassed.
Well, that's what they say, trespass.
Okay, well, I want to talk to you about this particular trespass. Where did it occur? And if, let's see, I guess I could look up the complaint.
I think it's Golden Gate.
Yeah, it's 14456 6th Street, Golden Gate Gas.
Golden Gate or something like that.
Hold on, Ms. Bonner Carey. Would you say the business again, please, Mr. Altum?
Yeah, it's Golden Gate Gas at 14456 6th Street.
Okay, so Ms. Bonner Carey, I want to tell you something that's going to save you from going back to jail.
Yes.
And that is this. You have been formally trespassed from that Golden Gate gas station. You were not allowed to go back there for a period of up to 3 years. So You need to stay away from that location. Do you understand?
It's an ugly place. I'll be away from there for
Right. If you go back there, you'll get arrested again and you have to come to jail.
I'll never go back again. You don't have to worry about it.
Okay, I'm ordering you to stay away from there, all right?
Amen. I agree.
All right, so I'm gonna go ahead and sentence you to time served here today. It sounds like you're working on things to alleviate your homeless situation,
Oh,
okay?
yeah.
Good luck.
Thank you. I
You're
appreciate
welcome.
it.
Your Honor, I'm sorry, I missed, what did you sentence her to?
Time served.
Thank you very much.
You're welcome. Aubrey Jarrell. Good morning, Ms. Jarrell.
Morning.
Your case number is 25 CR 13825. On September the 15th, 2025, you were charged with disturbing the peace, breach of the peace. Did you understand that charge?
No, nobody even said anything to me, and the cops just arrested me.
All right, Miss Jarrell, would you prefer, what's your preferred pronoun? Is it Miss or Mr.?
You can just call me whatever.
Well, whatever you want me to call you is what I'd like to choose.
Okay, miss.
All right, so Miss Jarrell, thank you. I'm going to go over the formal complaint with you that was filed on September the 16th, 2025, so you know why you were in custody and charged with disturbing the peace. Just give me a moment to open up that file. I have it now. And it indicates that at 1080 Bell Street in Reno, 89503, you were willfully and unreasonably subjected your neighbor to noise which is likely to disturb the peace of persons of reasonable and ordinary sensibilities. So it's a noise complaint, Miss Jarrell. And can I confirm your last name? Is it Jarrell or is it Madison?
My middle name is Madison.
Okay. All right. So Jarrell is your last name then?
Mm-hmm.
Yes.
Yeah.
Thank you. And is it Jarrell?
Yep, that's how you spell it.
All right, thank you. So you understand why you were arrested?
I guess nobody even said anything to me that I was annoying them or anything. I was just having a mental health issues.
Okay. So
I wasn't doing that to just.
So Ms. Jarrell, I'm going to defer to your counsel. Have you had a chance to speak with Ms. Jarrell, Mr. Loomis, and what plea do you think that should be entered here this morning?
Judge, I have talked with her. She indicates, and I explained the circumstances of the disturbing the peace and that it was involved a person that works graveyard and sleeps days, and his sleep was being interrupted by yelling in the alley. So I think she understands that that's what the basis for the charge.
I didn't mean to do that, though.
She does indicate she has mental health issues and is on medication for psychosis, and that she hears voices and she has difficulty responding when the voices are speaking to her. Now she seems to be okay today. So I proceeded with it. I'm not asking for a competency evaluation at this point.
All right, thank you, Mr. Loomis. How do you wish to plead to the charge of disturbing the peace now that you know what the facts are, Ms. Jarrell?
I guess no contest. I just didn't even know I was I didn't even know I was making this person mad. I don't know.
Okay. Well, do you have a right to enter a plea of not guilty and set the matter for trial if you'd like?
No contest, right? And then you have him talk or.
Right. And you understand that by entering a plea of no contest, I'm going to find you guilty of the disturbing the peace charge. Do you understand?
Sure.
Well, I want you to be clear about this because you're going to have a criminal conviction for disturbing the peace. Do you understand that?
Okay.
All right. So do you still want to maintain your no contest plea?
Yes.
All right. I'm going to go over those constitutional questions with you now. You understand by entering a plea of no contest or guilty, you give up the right to have a trial in this matter. You understand? That's a yes or no question.
Yes.
All right. And do you understand that disturbing the peace is a misdemeanor offense for which you could be sentenced up to 6 months in jail or fined up to $1,000? Are you aware of that?
Yes.
All right. And have you served in the United States military? You have to answer out loud because we're being recorded.
No.
Thank you. I will accept your plea of no contest as freely, voluntarily, and knowingly entered. Do you need to continue this over, Mr. Altum, to have the victim present?
Yes, I'd note there's possibly up to 3, but more likely 2, even though there's only 1 count. So we would ask to set this up for sentencing.
You want to set this for tomorrow?
Yeah, that would work.
All right. So, Ms. Jarrell, the city attorney has the constitutional right to ask for time to bring the witnesses, the people whose peace you disturb, to come forward to make a statement to the court at the sentencing. So I'm going to continue your matter. You'll be held in custody until tomorrow. So we can have those victims present. If they don't show up, we'll still go forward with your sentencing tomorrow. Do you understand?
Yes.
Do you have any questions?
Yeah. No, never mind.
Okay. All right. We'll see you tomorrow.
Don't know what's going on.
You'll see another judge tomorrow at 8:30. Okay.
Okay.
All right.
Jen, did you want to do a no bail holds?
Yes.
Okay, thank you.
Jason Martinez.
Judge, okay.
I have 2 matters for Mr. Martinez. Good morning, Mr. Martinez.
Good morning, ma'am.
The first matter I have looks to be a traffic matter, 25 TR, which stands for traffic 12901. I'm opening up that file now to tell you what it is. And it looks like on August the 22nd, 2025, sir, you were charged with driving on a canceled, suspended, or revoked driver's license. Did you understand that charge?
Yes, I do.
All right, sir. And then I'm going to move on to your other matter. And that is 23 CR 13378. And that tells me that this is a 2-year-old criminal matter. I'm opening up that file now, sir. And it looks like you were charged with failing to register on October the 14th, 2023. You were found guilty of that. And then it looks like a failure to comply with a court order or pay a fine was charged but dismissed by the court later. But you have 2 failures to appear, one on June the 10th, 2024, and one on 9/3/2024. So it looks like a motion was filed on June the 30th, 2025 to dismiss the outstanding warrants. Did you ever register as a felon with the Reno Police Department, sir?
Yes, I did.
All right, let's see what. Oh. And as of August the 11th, my notes indicate that the motion was denied and that your warrant remains active. So let me look at the motion that you filed and see what if we can resolve this issue.
Yes, ma'am.
All right, your motion filed June the 30th, 2025 is a bit lengthy, so I will tell you. Informal hours completed 16 total because this was another member hours were not considered by the church the only verified amount. Then later, JM completed 16 hours and verified by Catholic Charities. The court received all documents required. Please quash the warrant to failure to appear on show cause as JM, that's you, did not intend to mislead the court, the original work. So basically you claim that you completed the community service. Is that correct, sir?
Yes, I completed it a second time because the first time was not recognized by the court system, and I just wanted to say that I wasn't trying to mislead the court. So I repeated it and did it through a recognized Catholic Charities to take care of my responsibility.
All right. And you say you have already registered as a felon with the police department, is that correct?
Yes.
All right, and then what I'm gonna do is, I'm gonna go ahead and dismiss any outstanding warrant and, well, let's see. I'm just gonna go ahead and close this case and dismiss the outstanding warrants in this matter. When were you arrested on these charges?
15th. The 15th.
On the 15th, okay. And today is let's see what day it is. Today's the 17th. So let's deal with the traffic matter. Is there an offer to be tendered to Mr. Martinez relative to that charge? Mr. Elton?
Yes, Your Honor. First, I'd like to know if defense is willing to provide this information, when and why his license was suspended.
I might be able to shed some light on that. What he reports is that he was involved in obtaining SR-22 insurance information for DMV. There were some problems with that, and he had at one point he had 2 insurance coverages, but it looks like it has nothing to do with the DUI or implied consent or anything along those lines. It has to do with insurance coverage. It looks like he's been working at trying to get it taken care of. And what I'd ask the city to consider is a no valid driver's license.
That's what I was thinking. My question though, like, is I guess gets back to when it was suspended initially.
I don't have that information.
I had an appointment and it's September now, a couple weeks, I think in August, and with the DMV, and I had already had the SR-22. I actually had 2 different insurance policies, and they didn't know about the new one, I guess, because I transferred from Progressive to Dairyland. So I had the SR-22. I had proof of that I never lapsed the coverage, and I had an appointment. The only problem is I didn't go to the appointment because I didn't have the money to pay the fine, because I think it's $75 to reinstate. So I don't know if I would have actually gotten a suspended, because I had proof that I did have the insurance in the interim. So, but I didn't make the appointment, so I had to reschedule it. And I do have an appointment here on the 25th to go back to the DMV and show them proof that I did have the SR-22.
Your Honor,
I will have the money to pay the reinstatement fee at that time.
I still haven't got an answer to my question, but based on our general dealing with the DMV and the records that they keep, I'm willing to have him plead to the no valid.
All right. So, Mr. Martinez, the city attorney is cutting you a big break. He's going to amend the charge down from driving on a suspended license, which if you got convicted again for that, the DMV would suspend your privileges for another year. So he's amending the charge down to not having a valid driver's license, which allows you to get a driver's license. Do you want to go ahead and accept that offer?
I think that sounds fair.
What is your plea to the amended charge of no valid driver's license?
That would be guilty. I'm guilty of that.
All right, sir, and you understand your constitutional trial rights, correct?
Yes, ma'am.
You have any question about your rights?
No, ma'am.
You understand that the maximum penalty could be up to 6 months in jail and or a $1,000 fine?
Yes, ma'am.
And have you served in the military?
I have.
You're a veteran of what branch of the service, sir?
Navy.
All right, so veterans always get a break with me. I'm the Veterans Treatment Court judge. So what I intend to do is this, Mr. Martinez, I'm going to go ahead and sentence you to time served on the no valid driver's license. And the other thing I'm going to tell you is this. If you go over to the Washoe County Library next Wednesday morning at 9:30, Catholic Charities can provide you a voucher worth $45 toward getting a new license.
Oh, really?
Yes, and then if you need other services, they have job placement, bus passes, a free lunch, medical insurance, Medicaid. There are about 30 local providers, so I can't list them all. But I strongly urge that if you need some financial assistance, to go over there and get that help that you might need to get back on your feet. Okay?
I appreciate that, ma'am.
All right, so you're sentenced to time served on the no valid driver's license. Washoe County Library is located on the corner of Center and Liberty Streets downtown. It's held every Wednesday at 9:30 in the morning, okay?
Thank you, ma'am. I appreciate
All right, you should be released today, Mr. Martinez.
Thank you, ma'am.
You're welcome.
Okie dokie, friends. We've run a minute or two over. That's okay. So, Dawn, hi. I'm the guy in the corner. My name is Dan. I run the Courtroom Files. Nice of you to join us today. I'm glad you stumbled across us. We've had a nice back and forth in the chat for those of you on the podcast side who are wondering what I'm talking about. Dawn found us today, and we, again, have had a nice back and forth. We do things a little differently over here. We move around between different courtrooms. We comment on what we see. We have a great back and forth in the chat. This is the best community in law, to period, end of sentence. I don't care what anybody says. And I'm not just saying that because I run it, Dawn. This is good people here who really care for each other, have my back for sure. They have the backs of everybody out there, and hang around. You'll like it here. If you really want to learn about us, become a channel member. It's $2.99 a month. Give it a try for a month. You get early access to our videos. You get access to the pre-show where I let down the 5 strands of hair that I still have and kind of speak my mind, and we interact and talk there. Members really enjoy that, so consider giving that a look. But in any case, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, half an hour early again for channel members. And tomorrow night we'll have Sidebar as well at 8 p.m. Eastern, 5 p.m. Pacific. Dawn, that is where 3 channel members actually join me, and we have a panel discussion on things, so that's fun as well. But go make yourselves a great Wednesday, which, as we've said before, is the new Friday. Enjoy your day. I look forward to seeing you all tomorrow. In the meantime, take care. God bless.